All in favor of approving the July 8th, 2025 board meeting minutes? Say aye.
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 Any objections? No objections, and they are approved as and duly ratified at this time. We'll go now to the amended briefly discussion and go directly to the executive director's updates. Typically, we go to PIC comments, but we have 17 comments at this time, and we want to make sure that every person in custody is heard. And that will take about 30 to 35 minutes to hear those concerns from PICs. And this is a result of the time lag in not having an August meeting. So they will be heard, but we just moved it briefly in the program. Okay. And I'd like to note for the record, we do have Vice Chair Skip online. Welcome, Vice Chair Skip. And
Thank you, Chair Sampson.
okay, so now we'll go to our Executive Director for updates.
Thank you. Good afternoon, everyone. Thank you for joining us today. Since the last board meeting, there have been 5 deaths in custody. Christian Collado, age 51, died in Bellevue Hospital Prison Ward on July 9th. The Office of the Chief Medical Examiner report states that Mr. Collado had ampullary cancer and had a cardiac arrest on July 9th. Edwin Quispy died on July 22nd in EMTC at age 33. Mr. Quispy was found by a person in custody unresponsive in the housing area bathroom. The person in custody notified DOC staff who activated a medical emergency. Mr. Quispy was pronounced deceased by medical staff on the scene. Ardit Bila died in GRVC on August 23rd. He was 29 years old. Mr. Bila was discovered in his cell unresponsive by a correction officer. DOC staff activated a medical emergency response, and Mr. Bila was pronounced deceased by medical staff shortly thereafter. Jimmy Avila, age 34, died on August 30th in West Facility. DOC staff activated a medical emergency after discovering Mr. Avila unresponsive in his cell. Mr. Avila was pronounced deceased by medical staff on the scene. Carlos Cruz, 43, died on September 3rd in GRVC. A person in custody alerted DOC staff that Mr. Cruz was in distress in a cell. Medical staff arrived following the activation of emergency response. Mr. Cruz was pronounced deceased shortly thereafter. Causes of death, except for Mr. Collado's death, are currently pending confirmation from the Office of the Chief Medical Examiner. We extend our deepest condolences to the families and loved ones of all who have passed away in DOC custody in the past 2 months. As with all deaths in custody, the board is actively investigating and will issue a public report on its findings. A public report covering deaths that occurred in February and March of 2025 will be issued in the coming months. A report on the deaths that occurred since June 2025 will be published by the end of the year. We also share our deepest condolences with the families of department staff who have passed since the board's July meeting. The staff who have passed are retired Officer Margaret Ann Corbett, retired Officer Gregory Pringle, retired Captain Janine Sullivan, retired Officer Gloria Berry, retired Captain Estanislao Perez, retired Officer Dakita Whitehead, retired Officer Pascal Anthony Ciarasiari, retired Officer Omar Alston, retired Officer Andrea Mayo, and retired Officer Carrie Ann Stewart Jr. And regarding the census data, as of September 8th, 2025, there were approximately 7,194 individuals in department custody, a 6.5% decrease from July 7th. Broken down by facility, as of September 8th, 2025, in Bellevue Hospital Prison Ward, 68 individuals. Elmhurst Hospital Prison Ward, 11 individuals. EMTC, 1,504 individuals. GRVC, 957. And NIC, 290. OBCC, 1,553. RESH ESH, 139. RESH non-ESH, 381. And in RMSC, 440 individuals. RNDC, 1,113. West Facility, 733 individuals. Regarding reports, BOC's semi-annual monitoring report will be issued in the coming weeks. Also, as mentioned, a public report covering deaths that occurred in February and March of 2025 will be issued in the coming months, and a report on the deaths that occurred since June 2025 will be published by the end of the year. And that concludes the staff updates.
Excuse me, Chair.
Thank you,
Can you hear me?
Jasmine. Board Member Stasso, if you may.
Oh, thank you, Chair Sampson, and thank you, Jasmine. I know we don't have, oh, it's not, really? Can you hear me now? It's too far away from me. Thank you. I know investigations into these deaths are ongoing, and obviously it's incredibly upsetting to hear anytime somebody dies in custody. I think it can be really helpful to just look for systemic issues or patterns where some sort of intervention might be helpful. As I was reviewing just the preliminary findings, it seemed like the frequency of DOC tours was a pattern in, I think, about 4 of these deaths. And just, you know, without allowing too much time to go by, I wanted to see if someone from DOC might be able to speak a little bit about whether there's anything being done to ensure that touring is happening at the every 15-minute frequency that it's supposed to happen with on the mental observation units, since I think, in some of these cases that may have been life-saving. So I was wondering if someone could speak to that.
Good morning, afternoon, Jim Conroy, General Counsel for the agency. As was mentioned at the start of this, these investigations are ongoing, as is in our internal reviews. So we're not going to be making comments on these incidents or patterns or practices right now.
Excuse me.
Thank you, General Counsel. Thank you, Board Member Stasso. I see. Board Member Stasso has been appointed to the DEF committee as well. So she will be working with Chair Jude Torsant at this time to, one of the issues that may come out of that committee is systemic causes. Back in June, I did ask staff to look at comparative jails, around the country with patterns of deaths of persons in custody. We're not prepared to share those findings, but they are, revealing, and I think it would be more revealing with further review and research. One of my biggest concerns as chair and becoming chair was to address deaths in the jails. And there appears to be some uptick at this time with noting a lot of work that has been done to reduce the deaths in the jail. The introduction of Narcan was a tremendous impact on the deaths in the jails. But hearing Board Member Stasso, who has considerable experience and knowledge from working in the facilities and insight of her review capabilities, I think that this is something we must consider in looking at the systemic causes of deaths in New York City jails. A board member, a Vice Chair Skipper.
Thank you, Chair Sampson. Highly agree with Member
Cannot hear you.
Stossel. You can't hear me? Hold on.
Still cannot hear you. Still cannot hear you. We'll try one more time and then we may have to come back to you. Still cannot hear you. Okay, so we will move on in this. Okay, Board Member Skip, work with staff and so if we can get you back online to address your question.
Thank
Thank
you
you.
so much.
So again, thank you, Jasmine. Next, the board committee to review BOC's minimum standards, receive concerns raised by New York City criminal defense organizations regarding department's compliance with the board's access to counsel minimum standard, BOC minimum standard 1-08. The board has shared these concerns with the department ahead of today's meeting to allow the department to prepare a response. Two representatives from the criminal defense organizations, Mr. Michael Klinger and Mr. Christopher Boyle, will now present their concerns. And gentlemen, if you can just give me 1 second, you can prepare yourselves. Board Member Skip, Vice Chair Skip, I think that your mic is working now, so you can ask your question.
I'm sorry. What did you say?
You can
Can
ask,
you hear me now?
we can hear you now. You can ask your question.
Okay, great. I was going to get my headsets because I was like, it must be me. In regards to what Member Stossel said, yes, there seems to be some, I want to say, adverse circumstances. But what I would like to know, even though DOC is not commenting on this now, if and in fact it looks like that staff is not touring regularly as per minimum standards, I think we also need to look at what are next steps if this actually comes down the pipe, and I believe it will. We need to look at what are next steps if staff is not touring when they're supposed to be touring, and these things probably could have been prevented.
Yes, and
What are next steps?
well, thank you very much, Vice Chair Skipper. And as indicated, I will, as I serve ex officio on the DEF committee as well, that is one of the concerns that we will be looking at as well.
Thank you.
Thank you. Mr. Klinger, Mr. Boyle.
Good afternoon. Is this on? Can you hear me? Okay.
Yes.
Okay. Good afternoon. My name is Michael Klinger. I am a jail services attorney with Brooklyn Defender Services. I'm joined today by my colleague, Christopher Boyle, Director of Data Research and Policy at New York County Defender Services. We are presenting today on behalf of a group of New York City public defense organizations that represent people facing criminal charges in the city, many of whom are incarcerated in the city jails on Rikers Island. Next slide, please. This presentation, thanks. This presentation is the result of an ongoing dialogue initiated by the Jails Action Coalition and Halt Solitary campaign, which periodically seek to meet with new members of this board, both to share their own goals and priorities and also to hear from the members about theirs. In the course of a conversation last September between coalition members and board member Cozier, Judge Cozier invited the defender organizations to share information about impediments to people in custody having ready access to their defense teams and to their ability to participate in their defense, both critical pieces of the right of access to counsel that is enshrined in the federal and state constitutions, as well as state laws and regulations, including department regulations. The same group of defender organizations, also including representatives from the Legal Aid Society and Bronx Defenders, met again with Judge Cozier and board staff this past June. And at the board's invitation, we submitted a memo to memorialize that meeting and to inform the efforts of the board committee chaired by Judge Cozier, charged with considering possible revisions to the board's minimum standards. We thank Board Member Cozier, the staff of the Board of Correction, and each of the members of this board for the opportunity to present and highlight some of the ways in which department practices impact the rights of the people we represent to their access to counsel. We have organized this presentation around the three main ways that legal visits take place: in person, online, and by telephone, and then around the particular challenges for people held in enhanced supervision housing at RESH. Next slide, please. The department recently added two long-standing directives to its online resource page. Directive 6000R-A, originally from 1996, most recently updated in 2005, and Directive 6002, which became effective in 2000. These two directives lay out as a matter of policy a variety of processes which, if followed, would resolve many, if not most, of the issues we'll be raising today. Much of what we observe on a weekly or even daily basis in the jails amount to deviations from the department's own requirements as expressed in these two directives. While much of what we share today reflects the visitor's perspective, it is also critical to remember that people in custody have a right to access their counsel and to participate in their defense. The counsel visit processes we discuss often create barriers to that access, and what might seem like inconveniences for us, the visitors, are in fact denials of that right. If delays prevent us from seeing multiple clients, those individuals we don't get to see are effectively cut off from their defense teams. If poor conditions make communication difficult, our clients are not receiving the access they're entitled to. Like Judge Cozier, we raise these concerns because they implicate the fundamental rights of those in the department's custody. So, how do legal visits look from the visitor's perspective? The process of visiting someone in the jails for legal visitors begins at the Perry Building, which is the first building you arrive at after crossing the bridge onto the island. At the Perry Building, legal visitors, whether they're attorneys or not, provide identification authorizing their visit, the name and address of their organization, and then they fill out a yellow card with their name and the name, book and case number, and facility name for the person they hope to visit. The staff at the Perry Building add the visitor's name to a paper logbook, issue a visit tag, stamp the visitor's completed yellow card, and apply a clear ink stamp to the visitor's hand. Sometimes, but not all the time, the officers on duty will call ahead to the facility to give them the name of the person in custody the visitor hopes to see, and this, at least theoretically, could speed up production and make the visit process a little smoother. This effort also, calling ahead to the facility, is required under the procedures section of the department's Directive 6002. The visitor then proceeds to the shuttle bus area, unless they're beginning with a visit to RNDC, in which case they can just walk straight to that facility. At the facility, the visitor exchanges their ID and the Perry Building tag for a facility ID, then completes front gate screening. The screening includes filling out one paper form per person to be visited at that facility, listing our names, our organization, our role, and the individual's identifying information. Sometimes, staff also require a separate blue card for each visit. Though the directives suggest blue cards are only for transfers between the facilities, confusion here is widespread. Perry Building staff direct us to get blue cards at the facilities. Facility staff insist they must be obtained at the Perry Building. The Perry Building does not have blue cards. Next slide, please. Except at NIC, visitors then proceed to a waiting area. Sometimes it's a bench next to the front gate security, as at West Facility, GRVC, at RMSC. Sometimes it's a waiting room, like at RNDC. That's the only waiting room. Sometimes it's a bench in a hallway, like at EMTC and OVCC. At NIC, the waiting space is actually a small locker room just outside of the security screening area. Their wait times vary widely. It is routine to wait for more than an hour after arriving at the facility before being called to the visit booth. Yesterday, I waited at GRVC for 1 hour and 10 minutes before being called to the council visit booth, and I considered that pretty good. Nevertheless, the duration of the wait and the department's failure to address it with any explanation or follow-up do amount to violations of Directive 6002. On September 2nd at RNDC, an attorney from Bronx Defenders waited 2.5 hours to meet with a client. The attorney sat through a shift change, and the incoming officer on the post said it was their first time in the role and admitted they didn't know what to do. But the directives do know what to do. The Directive 6002 requires that the council visit officer shall bring to the attention of the area supervisor any attorney visit that does not commence within 45 minutes of the attorney's registration at the Rikers Island Control Building, that's the Perry Building, or 30 minutes of the attorney's registration at the facility front entrance. The supervisor shall take immediate steps to locate the inmate for the visit and then initiate an investigation into the reasons for the delay. A written report of the results of the investigation shall be submitted to the program deputy warden. The next day, September 3rd, also at RNDC, a Brooklyn Defenders attorney waited more than 4 hours for a legal visit. After she requested to speak with the captain about the delay, her client was produced before any captain appeared. Although the directives require an explanation for delays of over 45 minutes, none was given. The client told his attorney he had only been notified of her visit moments before he'd been produced. It remains unclear why nearly 4 hours passed between the time that she arrived at the facility and the time that he was informed of the visit. The physical plant at each facility often creates additional challenges to in-person council visits. RMSC has only one booth, which tends to increase the wait times for visitors there. At all facilities, the visit booths are not consistently maintained in good condition. Sometimes there's no chair in a booth. Sometimes the only chair in the booth is a broken one. At RNDC, the lights in the booths don't consistently work, so visits are often conducted in the dark. At RNDC and GRVC, the plexiglass between the visitor and the person in custody is so thick that it's difficult for people to hear each other. This is especially concerning when the attorney needs to share discovery, often a very detailed conversation, or needs to get documents signed, a process that should require detailed conversation. This past July, a legal visit team had to end their visit early at NIC because their side of the booth was too hot. And that sounds glib, but they removed all of the items of clothing they could, and they sweated through the remaining items of clothing, and they couldn't continue. So they had to end their visit early. At West Facility, communication in the booths requires a handset, but some of the booths don't have handsets. So no communication in those booths is possible. Even when the booth does have a handset, there's only one, which means if more than one person from the legal team is there, they can't all communicate at the same time. At multiple facilities, the booths are not actually confidential spaces. At EMTC, for example, the plexiglass walls do not go all the way to the ceiling. And people in one booth can often hear people in the other. There's two booths. They can also often hear any conversation or, as it sometimes happens, very loud music playing at the officer's desk right outside the glass. Finally, in addition to the problems of the physical plant at each facility, there is occasionally worrying treatment by department staff. Attorneys this year are reasonably concerned after the highly publicized arrest of a public defender after a faulty contraband field test. The test was wrong, the charges were dropped, the case was sealed, but the frightening mistake by the department nevertheless creates a chilling effect for legal visitors. Shortly after that arrest, a council visit at OBCC was disturbed when a canine unit stood right outside the booth's plexiglass door, close enough to hear everything that was being said inside, and putting both the attorney and the person in custody in fear. Next slide, please. Sometimes, even after a long wait, a visitor is told that the person they came to see refused the visit, an action that is within that person's rights. However, we often hear from clients afterward that they never refused the visit, were never informed they had a council visitor, or were misinformed that they had court, a claim they knew was incorrect. In such cases, a refusal may have occurred, but only because they were misled about what they were refusing. And here, I think it's important to emphasize that visitors, legal visitors, provide their name and their organization name multiple times. They do so at the Perry Building, at the facility front gate, and again by completing forms at the council visit post. The department therefore has all the necessary information to inform the individual in custody of who is there to see them and in what capacity. We believe that sharing this information clearly would help reduce the number of mistaken or misinformed refusals. As for refusals, when we request documentation, it is only inconsistently provided. When it is, it often states simply that the individual, quote, refused to sign. Even in cases where the person later tells us they were never approached about a visit in the first place, and sometimes never asked to sign a refusal form. For these reasons, we believe that at least some of the refusals are fabricated. Next slide, please. Unlike with in-person visits, the department does maintain a process for advanced scheduling of virtual visits, what it calls video teleconferences or VTCs. In general, requests for VTCs must be submitted and approved at least 2 days in advance, and oftentimes it's necessary to request even longer in order to secure a particular time. Once scheduled, virtual visits face the same escort and production delays as in-person visits. On an individual basis, DOC staff and leadership are often responsive, and we appreciate Warden Caputo at the Criminal Justice Bureau, who frequently helps resolve issues when staff are confused or delayed. However, such confusion and delay remain common. It is routine in some facilities, particularly at RMSC, for a person in custody to be produced only at the very end of the scheduled 30-minute visit time. Several attorneys reported clients being produced to the booth with less than 5 minutes remaining in the scheduled visit. And even despite the efforts of staff on the post to extend the time, it is not always possible to do so. It is also routine when we are waiting for longer than anticipated to be informed that the person has allegedly refused only when we call the facility. This in spite of the fact that we have provided all of our contact information in the process of requesting the visit in the first place. And as before, the department does not consistently comply with our requests for documentation of such refusals. And even when people are produced in time for their virtual visit, the booths are also plagued by poor conditions. Last winter, we saw clients shivering in cold booths, dressed only in t-shirts because they had not been given proper warm clothes. This is a violation or a possible violation of other board minimum standards. This summer, we've seen people sweating and uncomfortable, sometimes needing to cut short a video because of the extreme heat on their side of the virtual conference. And the phone handsets that people use to speak in video visits are often poorly maintained, with weak or choppy connections that make hearing one another difficult or impossible. An attorney at Bronx Defenders reports having had 4 separate VTCs in the last 2 months, where either the audio or the video didn't work at all. So that's the process. I'd like to turn over our presentation to Mr. Boyle for a discussion of telephone access, including using the department-issued tablets for phone access, and then an update on access to counsel at RESH, and that'll be available for questions afterward. Thank you. There are
slides. Okay. So the next, can we go to the next slide?
Before you continue,
Oh, sure.
because you are going into a different segment.
Yeah.
I just like to give any board members any opportunities to ask Mr. Klinger any questions that might be relevant at this time, or if they want to hold. But I do want to give that opportunity. Mhm. Okay, hearing none. Thank you, Ms. Boyle.
Oh, can we go to the next slide, please? Okay, so we're going to talk a little bit about legal calls and how the legal calls work from Rikers Island. So sometime around 2008, the Department of Corrections changed their system from reel-to-reel tapes to digital tapes. In other words, their ability to hold on to recordings became much better for them, right? Now, in other words, prior to that, my understanding is that these reel-to-reel tapes, they would be taped over every 90 days or so, similar to 911 calls. But after that, they had the digital operations and they can keep these calls forever. Some of the problems that presents for us is that we, as lawyers, understand the reason why the Department of Corrections records phone calls, right? They record phone calls for the safety of the people who are incarcerated, as well as the members that are there, right? The corrections officers. That's completely understandable. But what this has turned into is these recordings have turned into an evidence gathering operation for the district attorneys in New York City. So basically what has happened is that they put in requests, the district attorney's office put in these, what we believe are automatic requests to the Department of Corrections through a subpoena process that is not overseen by the court. And all of these records, they basically ask, or these subpoenas say, any and all recordings. So they take every single phone call. The Department of Corrections takes those and gives it to the district attorney's offices. So, for example, we had a situation once where a young client was talking to his mother about an offer. And he was explaining on the phone call, right now I don't remember the number, but let's say it was 4 years. And he says, my lawyer's trying to get me 3. Later on, the district attorney had a conversation with one of my lawyers about the case, and my lawyer was trying to get the 3 years, and the district attorney said, he's willing to take the 4. Why we wouldn't offer the 3? He's already talked to his mom about it. So they had already overheard this, what should have been a confidential conversation between family members, but they turned that over to the district attorney's office. District attorney's office was able to hear that. And then there was no more need to negotiate because they knew that the person was willing to take the higher number rather than the lower number. Now, sometime around 2020, obviously we're all supposed to be on this do not record list. And when I say all, supposed to be the entire office, right? You know, we have paralegals, we have jail advocates who you hear every month, right? Come here and testify, who talk to our clients all the time when the lawyers can't talk to the clients. And we used to give a list. What we were being asked by the Department of Corrections is that certain people, like myself, were designated to give a list of people who were employed with our office and give numbers, right? It used to be just, you know, the office number, and then everybody was given cell phones. So then that changed into cell phone numbers as well as regular phone numbers, and we would turn that over to the district attorney. We assumed that as we were giving these numbers over, that they were placed on this do not record list. But sometime a little after 2020, we realized that Securus, which is the company that does the recording for the Department of Corrections, was actually recording many privileged phone calls. And by the way, turning these privileged phone calls over to the district attorney's office. So the district attorney, remember, nobody's listening to the calls before they go to the district attorney, right? So the district attorney is asking for every single phone call this person's made in the last 6 months, 7 months, whatever, how long they're on Rikers Island. The Department of Corrections doesn't review that for privileged material. They put it into a bow, they give it to them on a hard drive or CDs back in the day or whatever operations they have to give it to the district attorney, and they just turn that over. And the district attorney takes that. So sometime after 2020, we found out that they were doing these recordings of the lawyers. Brooklyn Defender Services in particular had a huge breach of, I think, as many as over 100 phone calls between lawyers was being recorded and turned over to district attorneys' offices. So at some point, the Department of Corrections tried to develop other measures for us to turn over phone numbers. So we began to use this do not record email. So we were supposed to email this do not record email to the Department of Corrections, give them a list of names, as opposed to giving them a separate list on a separate PDF. We were supposed to use this email to make sure that we weren't being recorded. Then we learned that the Department of Corrections has changed its policy, or seemingly changed its policy, that they're only allowing lawyers to be on the do not record list. And we certainly, obviously, we object to that. We have a number of people who are part of the team. Social workers are part of our team. Investigators are part of our team. But they're asking very specifically for the lawyer's identification number on their website. We've had meetings with the mayor's office. They've talked to the Department of Corrections. There's some claim that no, they'll still take the paralegal's information. They'll still take the information from other people, but that doesn't seem to be on the website. And this is what ends up happening, is this constant talking past each other and confusion about what the policies are in terms of what should be getting done, right? Everybody in our offices should be on that do not record list. These are all privileged conversations. And yet we're struggling to figure out who to give that information to. We're constantly turning over people, right? You understand that we don't keep people like we used to in public defender offices for 20 years. Sometimes people leave after a year or two, and then we get new hires. And this is a constant flow of information that has to be given to the Department of Corrections. And when they change procedures like this without consulting anybody or without telling us, it presents lots of problems for everybody. So do you have any questions about the phone call stuff? Because I'm going to move on to the ESH area and answer any questions you might. Yeah, certainly.
I had a question. In terms of the recordings, are they saved or stored on a server?
They're stored in some digital capacity. I don't know if they're on a cloud or if they're, I'm sure they know the answer to that, or their tech people know the answer to that. But their capacity to save recordings now is pretty much, they can save every single recording for somebody that's in the entire time they're incarcerated.
So additionally, it should be understood that all recordings should be confidential. So how is it that the DA's office is able to, I guess, obtain access to those?
Because if they're not on a do not record list, those calls get recorded. And because there's no screening mechanism by the Department of Corrections, in other words, no one's sitting there listening to it to make sure that there's a number on here or there's a person on here that's a privileged communication. They just take all of that material and just say, here, DA, have a field day. And that's exactly what happens. District attorney gets access to all that information because nobody at the DA's office is doing the same thing. They're not screening and not listening to the phone call. Like they're listening to the phone call after the fact and saying, oh, wow, that was a lawyer. I probably shouldn't have listened to that, I'm assuming. But I'm not in the DA's office. I don't know what they do. But I know that the Department of Corrections is not screening those phone calls.
Thank you.
You're very welcome. Okay, so I was going to move on to the ESH area. So that's the enhanced housing area. I'm sure you're all familiar with that. I just want to give a brief understanding of what it used to be like. So ESH used to be in GRVC. There was also a small area at NYC. The procedure, as far as I knew, for the Department of Corrections was, my understanding is they needed a captain to escort the client to the council area. That really meant nothing to us other than sometimes having to, us being the lawyers, other than having to wait a little bit longer for that client to be brought down, right? So they would let us know your client's in the booth and we'd go in the booth and we'd have a conversation. Now that booth is the same booth that I would talk to anybody who was in general population. It wasn't a difference. So it didn't affect us in any way other than the time, right? It might be instead of an hour, it might have been an hour and a half or an hour and 45 minutes. And due to their staffing, maybe sometimes 2 hours, right? So it was a timing thing, not in my view, a dangerous thing, which is what I'm going to get into right now. Sometime in July of 2023, they changed that and they put ESH into the Rosie building. Now, I believe I was the first person to visit ESH when they moved it to the Rosie building. And so my experience was as follows. And I think I testified to this 2 years ago when it first happened. Basically what had happened is that I would show up at the Rosie building and I said, oh, I'm here to see a man, right? Obviously that the RMC, the Rosie building is for women. So they didn't have any idea what the procedure was. In other words, they changed where they housed people, but didn't have a procedure ready to go when we came to visit. So I was like, well, you know, I'm here to see somebody who's in ESH. I want to go see what's going on over there. And they're like, okay, well, you just have a seat and wait. We have to find somebody, and they use the word escort you to this area. I'm like, okay. So I sat and I waited. About 2 hours later, somebody finally came and escorted me. I literally walked through the entire jail to get to the ESH area. Right? So it's all these different doors, all these different areas, all these different units. They escort me in to what looked to me, because I've seen video of it, of a dormitory, basically just like any other dormitory that was empty. They brought the client in. I sat in what would look like a jail cell on one side, and on the other side, the client was there, and there was a plexiglass in between. But what concerned me was right outside the door, there wasn't anybody. There was no officer sitting outside. There was no, what would be an officer clocking you in. Like all these places, they have books where you sign in before you see a client. There was none of that here. I sat in, I talked to my client for about 15 minutes. I didn't have, to talk to him very long. I needed actually him to sign something. And then I walked out of the room. And when I walked out of the room, there wasn't anybody there. So then I wandered around. I walked down the staircase. I started banging on some doors to try to get somebody's attention. I could kind of see the bubble. And you probably have heard that term before. From my vantage point, somebody finally saw me, opened the door, and then I was in like a kind of a hallway that had like 6 different doors on it, almost like I was in the hub. I waited. Nobody was there. The original officer that I had was gone. They brought another officer came in and they're like, "What are you doing here?" I'm like, "I'm here. I had an interview with somebody at ESH." They're like, "Oh, we have to escort you back out." I'm like, "Okay." And then there was an officer that seemed like she wanted me to follow her. So I followed her. I walked out, I walked all around, and then I realized I wasn't going in the same direction I was coming. And I'm like, "Where are you taking me?" And she turned around. I'm a pretty big guy. I'm 6'5". I think that she wouldn't have missed me. But apparently she said, "I didn't know you were following me." So here I was just wandering through the jail. Nobody knew where I was going. Nobody knew what was happening. But she finally escorted me out to the front of the area. At that point, I told the people that work for my office, nobody's going to ESH until we find out what's going on, because it was a very dangerous situation. I did not know what was happening. After that, what they started to do is instead of walking people through, they started to have buses taking the lawyers around the building to the area, I guess, where that area is. There's another door, I guess, behind the building. And what was happening at that point is they were using the jail buses. So they were locking lawyers up inside the pen area of what looks like a school bus, but it's a jail area. And they were like, "Oh yeah, you have to be locked up. We can't do it any other way." Well, obviously this didn't set well with all of us. We complained. And then finally they said, "Okay, we've got a regular car that will take you around." So, okay, so we thought the issue had been settled. And so now what was happening is that we were going from the Perry building to the Rosie building. And then at the Rosie building, we would wait for this car. This car would pick us up. The car would drive us around back. And then we would go see the client, until I got word that they were locking lawyers up in this very small room prior to seeing a client. So you hear Mr. Klinger, right? Sometimes we are waiting not just 20 minutes for somebody or 10 minutes or 15 minutes. We are sometimes waiting 4 hours for someone to be brought out for a counsel visit. And what they were doing is that there was no waiting area in this area of ESH. And so what was happening is they claimed that they didn't have enough staff. And so they were like, "Sorry, for your own safety, you have to be locked in this room." This room had no communication. There was no like phone to call out. There's a window, but it's padded up with paper, so you can't see out. No one can see in. And there's no bathroom. So at that point, we took what's called a right to counsel writ in front of a judge in Supreme Court, basically saying that this violated our right to counsel. There was no way that I was going to allow members of my office to be locked up in a room for who knows how long, waiting for the Department of Corrections to open that room and then let us out. So we had people testify at this hearing. Several of my jail advocates testified at the hearing. Department of Corrections put somebody on, but it was very clear that the wind was blowing our way, that the judge was probably going to rule our way. But she wanted us to see if we can mediate in some way and work this out, which I was more than willing to do. So then we had conversations. What could we do here? So at first they were saying, there is a waiting area, but it's for family members. And I'm sure you're aware that the family days are different than the lawyer days. For the purposes of the writ, I was prepared to be satisfied with the idea that my lawyers and my people could go on the days that the family members could go. And that would mean that they would be in the regular waiting area and they wouldn't have to be locked up in this room. And then they would be called to go in and talk to the clients when the client was ready. But what ended up happening is that now, because they went in a family waiting area, Department of Corrections said, well, they have to be subject to a search, the lawyers. Now, I'm not subject to a search other than the mags when I first walk in, right? I don't got to take any clothing off. I don't get a pat down. I don't get anything like that. I am a lawyer. That doesn't happen to me when I go there. But in this scenario, because I'm in the family waiting area, their claim was, well, that's a different scenario. Now you have to do all these searches because you're sitting in the family waiting area. And I'm like, this is not my problem. This is your problem. I'm doing this to accommodate you in some way because you don't have enough staff. And so we tried to talk it out about, well, what would this search be like? And they were like, well, it could be a pat down. I'm like, okay, well, why don't you write that down on the website? So the lawyers are aware that when they go into ESH, this is what was going to happen. And their position was, well, we can't do that because we can't account for how detailed the search could be for any person that goes into this area. And that's when everything broke down. And I was like, well, then we're not going to agree. So the judge finally did get to a ruling and we won. The judge wrote a decision. I think it's attached to the materials that we gave you. And the decision was, this area has to be treated just like any other area. The lawyers don't have to wait for the family days. The lawyers are not to get locked in a room. Department of Corrections is to work out the situation just as if we were visiting RNDC, GRVC, or any of the other locations. And then the Department of Corrections appealed. So we are in the appellate procedure right now, waiting for the Department of Corrections to perfect their appeal. We are in the process of trying to get the stay lifted because they're a city agency, they get an automatic stay of the decision from the judge. But that's where we are. But this continues to be a very dangerous situation. We had a pregnant woman from the Bronx Defender Services that was locked in this room for a couple of hours. And you can imagine what that must have been like for her, locked in this room, waiting to see a client. But right now we're in the position where we're waiting for the appeal to be perfected and we're going to argue our appeal in the appellate division. Any questions on that particular issue that I can answer?
That concludes your full
Yeah.
presentation.
Yep.
Any board members have questions at this time? Board Member Skip, I know you're remote. Do you have any questions?
Yes, on that, I just want to say that I'm absolutely very sorry about the trials and tribulations that legal counsel has to go through. I myself have went through the same thing when I am visiting a client under my job as the executive director of the New York City Justice Peer Initiative. And just want to offer my apologies for the trials, the errors, and everything, and just trust that I have been through the same thing.
Thank you, Vice Chair Skip. Board Member Stasso?
Yeah, thank you. This is really helpful to understand. I'm wondering, Mr. Klinger, if you can tell us what the directives actually say, the two directives that you mentioned. I know I didn't quite get what the directives are, and I'll write them down and can look, but if you have it and could tell us.
So thanks for the question. First, I'll say I don't have a copy of the two directives with me, so I can't tell you, but they're a couple of pages long, each of them, and you wouldn't really want me to read them to you, even though I did include in my prepared comments an extended quotation. But they can be found on the Department of Corrections website. I forget exactly how you navigate there, but if you just Google Department of Corrections and directives, you'll get there. They're sort of towards the top of the list, and I'll just add, I think that the board's decision to put this on today's agenda was incredibly helpful already, in that those two directives were not there at the beginning of the summer. They come from 1996, they come from 2000. The department doesn't put all of their directives up, and I understand why, there's a lot. But those two have been really enlightening to read, and so I hope you will find them on the department's website.
Thank you. And then I also just wanted to get a sense of what the time course was that this became problematic, if you have a sense of sort of when these problems started happening in terms of access to counsel.
Okay, well, I think that's a great question. They there's some litigation that's almost as old as I am, called Benjamin, that is the Legal Aid Society brought in the 1970s. And it's taken a million different forms, but in my looking into concerns around access to counsel and Department of Correction, Judge Harold Baer, now deceased, but in the Southern District of New York, was heavily involved in this Benjamin case and wrote really beautifully, as he often wrote, about some of the exact same issues that we're discussing today. So some of these issues were the subject of a consent decree, maybe multiple consent decrees in the Benjamin litigation. At various times, the department has probably improved things. We know that, for example, on these yellow cards that I referred to, the department previously had a version of those cards that included something like a Bill of Rights for legal visitors on the back, said you've got, after 45 minutes, you're entitled to ask for a captain's explanation, et cetera. The newest printings of those cards don't include that Bill of Rights, but it was interesting to see in these directives that have been recently posted that they are there. They were absolutely mentioned and contemplated by Judge Baer in the Benjamin litigation so many years ago. So although I can't answer your question, I can honestly say I think it's been a very, very long time that these have been issues.
Thank you. And then just one question for you, Mr. Boyle. I'm curious if you can speak to how you are directing your attorneys right now in terms of affording counsel visits, given these concerns and maybe particularly in ESH.
Well, the ESH area, I've directed them not to be allowed to be locked in the room. So I've been instructing everybody that if they have to go to ESH and visiting ESH, that if the officer says you have to be locked in the room, to leave, and we'll have to do a video conference. I do not want them locked in a room when the department is already short-staffed. They're already saying that they're short-staffed. And now they're locked in a room where they have no ability to get out. This is not a situation where right outside the door there's an officer. Like, there's occasionally we will go into a counsel room and speak to a client and they lock the door. But literally the officer is right outside and there's other staff that's right outside that room because those are counsel areas. This is like a dormitory. This is like another jail part, really inside the jail area. It really wasn't made to be a counsel area. So you have to understand that that's the big difference here. So that's the instruction that I have given my staff.
And do you have a sense of what number or what percentage over the course of the last few months of visits have been sort of unable to take place because of these problems?
Well, I mean, ESH is not a permanent housing area, except apparently now there's general population there. And that's been a kind of a new thing. They have now put general population folks in the ESH area. So that could present some problems. But with ESH, it used to be that they, did 30 days or 90 days in ESH, and then they would be moved to a different location. So it was never permanent in the sense that once the person was in an ESH, that we wouldn't be able to visit them. We waited a month or two for whatever the sentence was, so to speak, to be over. It's hard to say what percentage is. My guess is somewhere around 10%. We have a rotating jail population of our office of around 300. My guess is there might be anywhere between the max, maybe 20 people in ESH at any given moment, max. So it's not that many, but the problem is that it just makes things impossible. And it's the reason why we took the writ, and it's the reason why we won the writ, right? Because the judge realized the impossibility of what we were dealing with, and that was just not something she was willing to consider for the Department of Corrections.
Thank you both for the presentation. I really appreciate it.
Very welcome.
Yes, before I go to Judge Crucier, just to follow up to Board Member Stassel's question. Did you access to counsel? Do you have overall percentages or reports that you presented to the courts that the impacts?
When I had the writ, you mean?
Yes.
We had testimony. So I have two jail advocates who testified about their experiences going and trying to see clients in the ESH area and the fact that they were being locked up and what was happening. And obviously the judge was free to ask whatever questions the judge wanted. So whatever that testimony was satisfied the judge that, our right to counsel was being impeded by the fact that this area was not in the same way that all the other areas were. And that's what the ruling was, basically, that the Department of Corrections had to fix that and had to be in a situation where the area was supposed to be just like any of the other facilities that we would visit.
Thank you. Judge Corsair?
Yeah, mine is more of a comment rather than question. During the course of the last year, I've had the opportunity certainly to meet with certain representatives of the legal advocacy groups, including, of course, the legal defense organizations. And certainly they have brought to my attention many of these issues, which have now been made a part of the record. And I have to say that we should understand that the right to counsel is the most fundamental right that a defendant has. And therefore, we cannot have a circumstance where there are recurring violations of the right to counsel. Now, the issue of the attorney-client privilege is critical. In order for counsel to provide a proper defense for any defendant, the attorney-client privilege is sacrosanct. And that privilege extends not just to the actual attorneys, but to their staff and agents who are privy to confidential information and communications with a defendant, with a PIC. And so it is extremely troubling to me because, of course, I have not seen these issues being remediated in any manner over the past of the last year plus that I've certainly served on the board. And so I think these are things that, you know, the department has to address. There have to be protocols and procedures here so that this does not continue the way it has gone on. This ad hoc manner of dealing with counsel and requests for visits, whether it's in person, by telephone, virtual, it's something that I think has to be formalized so that, yeah, there may be an occasional exception, but the exceptions cannot become the rule. And I think that's what we see. And I certainly have observed when I'm at certain facilities, counsel waiting in the area when I enter the facility and still waiting when I exit the facility. So, you know, I mean, I think it's very, very clear that these are violations, certainly, of the right to counsel and attorney-client privilege. The privacy and confidentiality issues have to be addressed so that confidentiality between attorney and client representatives can be maintained. And so I'm hoping that I'm going to hear from the department in terms of how they intend to address these issues.
You have a question?
Board member?
Yeah, as the non-attorney, I want to second the points just set up by the judge. I mean, New York is unique in the practice of our defense compared to other places that are doing work. We understand that defense has to be holistic, includes attorneys, includes social workers, sometimes include people with lived experience, sometimes include navigators. And that actually what makes us so proud of our New York institutions in terms of defense. That's the way that most places are trying to do it, particularly when you work with young people. You want to be able to have a team that includes the defense attorney sometimes, or sometimes maybe someone from the child welfare side, permanency knowledge, and particular education. So I feel really strongly based on best practices that it's not just about attorneys, it's about the team that so well you have put together in New York City for many, many years. That is the example of practice across the nation.
Yeah, thank you. Any other questions from board members? Well, I'd like to, you know, for the record, thank Judge Corsair for chairing the Minimum Standards Committee and meeting with the advocates on this and bringing forward critical concern. I appreciate the presentation. At this time, we'll move to the department and hear a response into one of the areas regarding your presentation as well.
Thank you.
Thank you. We will now hear updates from the department. We will now hear updates from the department. DOC response to access to council concerns and update on operations surrounding access to council requirements.
Good afternoon. Good afternoon, members of the board. I am Fritz Frage, and I serve as the Senior Deputy Commissioner for the Department of Correction. The department recognizes the importance of having access to counsel for people in correctional settings to ensure timely case processing. It is their right and their fundamental component of ensuring just outcomes in the criminal legal system. While we will not address every item raised in the defender's report today, I do want to make clear that the department takes these matters very seriously and will continue to ensure that there is no barriers to people receiving the access to counsel that they are all entitled to. We recently updated our attorney visits policy to permit attorneys to bring laptops into the facilities in order to allow for better preparation and presentation of legal documents to clients. The department recognizes that there is a room for improvement for the visit process and experience, including the attorney visit process, and we continue to prioritize that work. There is a broader initiative underway to improve, modernize, and streamline the visit process for everyone who is visiting Rikers Island. In addition, we have a free visit shuttle that leaves from Manhattan and Brooklyn to Rikers Island to ensure people have convenient and free mode of transportation to their loved ones. And more recently, we installed a free electronic lockers in this central visits area, replacing broken and outdated lockers. We hope that this will decrease the visit and wait time because of the additional locker space. These initiatives are designed to make the visit process clearer and more efficient for those coming to Rikers Island. As part of this effort, we created the position of Executive Director of Visit Operations, a senior leader whose sole responsibility will be to oversee, enhance, and support the visits process and experience, including the attorney visit process. We anticipate conducting interviews of candidates in the coming days and hope to fill this position soon. The new Executive Director, a first for visit operations, will be to maintain a point of contact for visitors and attorneys so they have direct line of communication and can provide feedback to improve our processes. This investment reflects our determination to ensure that visits happen smoothly and our desire to continue to improve the essential services. Regarding the defender organization's concerns, we have acknowledged that there are some work needs to be done, and we are doing it. However, it is important to provide balance and clarity. Several issues raised in the report are not reflective of current practices. For example, the concern about improper recordings of privileged calls is related to an incident that occurred years ago. At that time, the department immediately and fully cooperated with all investigations, took immediate corrective actions, and implemented safeguards with our vendors to ensure it would never happen again. Since then, there have not been complaints of this issue. The privileged calls are clearly outlined in our public website so that people in custody and their legal team can be assured that privileged calls are not being recorded. With respect in reference to the documents regarding the wait times for in-person and virtual attorney visits, tactical search teams, which is TSOs, count procedures, and other critical operations can disrupt movement throughout the facility and result in delayed production of these visits. It must be underscored that these are security matters, and safety and security for everyone visiting are paramount to us. The Department of Correction, the department cannot and will not publicly disclose detailed information about TSOs, shift changes, and other operational security practices for any reason, including to facilitate attorney visiting scheduling. Doing so would compromise the safety of staff, people in custody, and the public. We regularly review policies and procedures to align with the best correctional practices and to ensure all staff who have a role in the visits process clearly understands the protocols. We appreciate all partners for bringing any issues to our attention so that we can continue to provide the visits process for all. I appreciate the opportunity to speak to you and look forward to continuing this dialogue in a constructive and transparent manner. Thank you, and I welcome any questions at this time.
Thank you very much. We have one question. I think Vice Chair Skip, you have your hand up.
Yes, Mr. Friday. I have several points I want to make based on your statements, but I'll try to make this as clear and concise as possible. You first stated that the department takes these matters seriously, but yet you will not address all concerns. So how seriously is the department taking these matters if you cannot stand up there and address every bullet point that was given to us well ahead of this meeting? You also said that there are things that are put in place, but what you just discussed for family visits, and we thank you for making family visits very, very easier by installing additional lockers and things like that. But none of what you said about that applies to the matter at hand that we have in front of us today, which is attorney visits. And in my opinion, so you said up here and you said a whole lot, but there was nothing substantial in your statement that alleviated any of the concerns that I myself have gone through recently within the last 6 to 7 months. And I consider that recent. You know, I grow weary of hearing a response that says nothing, that means nothing. And that seems to be all that I seem to be hearing from the department. And that's all I have, sir. And there's no need for a response.
Okay, thank you. But if you like to respond, you may, department.
Yeah, I understand Chair Skip doesn't want a response, but just as a general matter to the board. A couple of things with respect to what was raised today and in response to Chair Skip's issue of not giving responses. With respect to the visit policy right now, as Mr. Boyle articulated, we're in litigation related to that. It's the city and our position that the judge in that case abused her authority and issued a decision that will be struck down. So on that point, you know, we can't comment beyond that. That's what the city's position is on appeal. Nonetheless, what Mr. Boyle articulated seemed to me to be at least a couple of years of conversation and compromise with the department. Not to their satisfaction in the end, but still something where there were issues raised and it's been adjusted and amended as we move along. You know, we invite the board to visit the room that they're speaking of. We have photographs of it, not with us here today, but we'll send it to the board as to what they are. There were mischaracterizations in the testimony regarding what was supposed to be a pat-down procedure in the searches. That was never on the table. It was a visual search where, you know, coats would be opened or otherwise. Some of this can't be publicized for security reasons, right? We're not going to put on our website what every single aspect of our front gate procedures are for fear that people will use the information to try to evade it. With respect to the phone call procedures, it's very frustrating that the breaches that were alleged or spoken about today were not only the subject of a DOI investigation, but the department has testified in at least several city council hearings, myself included. These occurred in or around 2019. And what it turned out to be, and this is what DOI found, was a technical issue related to our Securus platform, which is the company that provides phone service and tablet service and records these phone calls. The matters were addressed swiftly. Our current phone system, Judge, as far as understanding what's privileged and confidential, when you call, if your line is not a secure line, meaning it is being recorded, there's a dual admonishment that tells the person, this is not a secure line. This line is being recorded. If you require it to be so, hang up, and recall again. So anyone calling, it's not a mystery as to what's being recorded. On top of that, with respect to the staff of the offices, I think it's disingenuous for it to be represented that the staff have not been included. My team oversees, in the legal division, oversees and monitors the do not record email. We regularly have communication with defender organizations regarding other staff, investigators, paralegals that will also be included on those lists. What was happening, and what we corrected, was that, as Mr. Boyle seemingly indicated that he wanted to have happen, is we'd get one email from one person that said, we want these 30 phone calls to be on a do not record list, without any context to whom they're attached and what the role of the individual was. So what we ask now is just that each number be attached to an individual from the organization, and then that number will be approved to be put on there. That applies to, clergy as well. That's on our website. So, again, this notion from 2019 that this is a pervasive problem regarding recording is just not correct, and it's not an accurate representation of what's occurring now. In addition, the representation regarding subpoenas, that it's just a blanket subpoena issue. If that were the case, we would have, thousands, a minimum of 7,000, right? We have 6,000. We have about 6,000 pre-trial detainees in our custody or more. We would have 6,000 subpoenas for every single phone call. We don't have that. It is not. And the defender organizations would be receiving every single one of these recorded phone calls if that were the case in all of their cases. And I don't believe that to be true. And I know the subpoena unit falls under myself, and I know it to be true that we don't get 6,000, 7,000 subpoenas for phone records a year. So again, that representation is, seemingly disingenuous. I don't know if you have any other questions related to, we can't expand upon the ESH process. The senior deputy commissioner represented that this is an ongoing project. We are looking to digitize the visit process. We are aware the state has passed laws related to virtual court appearances. So in furtherance of that, we were going to be supplementing our virtual visit areas and processes to ensure that this is a more streamlined process. But I don't know if the board has further questions beyond that.
Yes, we do have further questions. We'll start with Board Member Stossel first. Board Member Skip, could you lower your hand?
I'm curious about whether you have a process of reviewing calls that are subpoenaed to ensure that privileged communication is not going to the DA offices.
We do not. Beyond the security protocol, that's not fair. The protocols to ensure on a digital aspect where someone calls and says that this line is not recorded and is being recorded and you should hang up and call back. Beyond that, we do not review every phone call. It would also be improper for us to be listening to privilege calls, quite candidly, and we'd be criticized for that in these forums as well. So there isn't a mechanism that we do to list them because we have hundreds of other subpoenas unrelated to phone calls. But when they recording, if we have it, is asked of the district attorney, we send it to them. It is the district attorney, they are lawyers too. They would have the obligation to share that it is privileged. And I think this is what occurred in 2019, that the DAs disclosed this information to the defense attorneys, and then it was revealed that these calls had been improperly recorded, and then all of the mechanisms within Securus and within the department were modified to ensure that this didn't happen again. And I, at least, am unaware of similar situations happening in a considerable number of years. Again, these were 2019. We are 6 years later.
Thank you. And I just wanted to clarify, are you saying that you are not restricting the list of privileged callers to attorneys only, that you are asking the defender services to associate a phone number with anyone whose calls should be privileged, and you're putting them on a do not record list?
That's correct. But I think with some parameters, it's, an investigator, a paralegal, someone within the office who would have that entitlement. I mean, I could envision people that work in law offices that may not, like a process server, that would not necessarily have that privilege extended. theoretically, I'm just throwing that out off the top of my head. But yes, anyone that reasonably should have that privilege extended to them, the office personnel, paralegals, investigators, summer interns we did this year. That is our process. Yes, that's correct.
So that process, that issue, it sounds like should be solved based on what you're saying.
As far as, again, to my knowledge, it should be. I don't know. I'm confused as to why it was raised here because, again, defender organizations, we have emails back and forth, and this was articulated pretty clearly to most of them.
Okay, so we can certainly clarify that.
Yeah.
And I'm curious about your understanding of why the directives are not being followed in terms of escalation along the lines of inappropriate wait times.
I don't have a direct answer for that as to with the directives as far as reporting and that the issues were raised. We're going to take that back, look into it, enhance our procedures. But, you know, again, we've articulated a number of times over, especially the last year, staffing issues. You know, there are reasons for delays. We look to mitigate them. And we, like I said, we are most particularly trying to enhance the processes with scheduled visits on some digitized platform to make it better. But that's something we could probably report back on, you know, what we're seeing. It seems to me, again, not, you know, these, even what was articulated seem to be on isolated incidents, but we will look at this and bring back to our staff the processes again.
Do you think it would be appropriate for to return to the practice of having the lawyer's Bill of Rights, so to speak, listed on the backs of the blue cards or the yellow cards to ensure that they can make sure that those issues are escalated when protocol is not being followed?
So I think we could take a look at all of the above. I think they brought up some really good facts, and we are doing a wholesale revamp, and part of that is looking at the attorney-client process. So we can certainly take that under consideration and figure out how we can streamline this. I think what also might be helpful is not sharing generalized statements, and I'm not minimizing what Mr. Boyd and his colleagues shared today, but we're running a full-scale operation, so we need the specifics, right? We have to understand jail is a very fluid space, so we can't just say that there were wait times. Was a detainee in another program? Did they deny their visit? And more importantly, when people deny visits, it's supposed to be on body-worn cameras. So we have processes in place to document this stuff, but I think to further the conversation, I would ask Mr. Boyd and his colleague to share specific detailed instances of what they went through with the board so we can actually look into them to help us in this revamp process to make sure that we're looking at the solution and not just the cure. Because I think you asked something very pointed. How long has this been happening? We can't say forever, right? We need detailed information so we can better our practices. So I think we can continue to further this conversation. We're very excited about this visit revamp. We appreciate the concerns brought to us, but I think to have a more robust and meaningful conversation, we can't say everything's bad. That doesn't help us as an agency. We need receipts. So if folks could share that information with the board, we'll kindly look into them to figure out next steps and how to better our processes.
Okay, I think that makes sense. It sounds like there were some specific visits where things went wrong. I think it would be good to have sort of a postmortem on some of those. Thank you.
I'd like to add one more thing in reference to the comments, in reference to the new position that we're starting to hire a new employee. It is not just for families. It's a direct access where an attorney, a family member can make a complaint as to the situation that they want to complain about. In this case, if they made it immediately, we can follow up with our camera system as they're moving PICs throughout the facility. They're on body-worn camera. We can immediately solve all those concerns and address them in a timely manner, as opposed to waiting for weeks, months later without any information, no times, no dates. So this position is going to help and enhance the relationship between the DOC and the family members and the attorneys that have concerns about their visits.
Board Member Joseph.
Yes, thank you. Counsel being locked up in a waiting area for an indefinite amount of time poses a significant safety concern. Has the department thought about anything that they could implement to mitigate that practice?
We, again, that's on the ESH front, so I can't expand too much on it because, you know, we're in the middle of the appeal, but I will say this much. Mr. Boyle rightly, I think, articulated that when family visits is open, that's where the attorneys will wait. The other aspect of that, and again, I encourage you to visit the area. I don't, you know, the room has ventilation, lights, benches, is more spacious than I think was portrayed, but unfortunately needs to be secure. because of the location of where it is. So, you know, that's something, again, we could come and look at, and we'll deal with that on the appeals issue, but, you know, without expanding further, I think I invite you to come see it.
Thank you. Will do.
Well, thank you for that invitation. I'd like to take it a little further and sort of ask our staff to get with the department and the defenders represented and sort of have a day or two to sort of review or audit access to counsel. This does not have to be announced, but I think that we need to review, because I don't know if we looked at what it looks like for counsel in protecting their clients' rights and having that access. So we will be following up on that. Thank you. And further, I respect the fact that, counsel, you've been asking for, I think your Deputy Commissioner Boyd indicated, more detailed accounts of, I'd like for defendants to present those detailed accounts beyond what's, I believe, cited in 2019 as being an issue. I think for the record, we would request any specific violations or appearance of violations or complaints so that we can evaluate further as to compliance with minimum standards. Okay, so now we'll move on to DOC response to concerns of impact of lockdowns on mandated services at OBCC.
Good afternoon again, sir. Members of the board, as I said before, my name is Fritz Faget, and I serve as the Senior Deputy Commissioner of the Department of Corrections. I would like this opportunity to directly address the concerns, misconceptions that have been raised regarding the recent lockdown at Otis Bantam Correctional Center, OBCC. First, I want to be very clear. OBCC did not experience a facility-wide lockdown lasting 5 consecutive days in August. As the board has alleged, the characterization does not accurately reflect the fact of what occurred. It is important that the record be set straight, as the accuracy is essential for public understanding, transparency, and for the integrity of this dialogue. Here's the facts. On August 8th and 9th, OBCC experienced a series of violent incidents, including slashings, fight, credible intelligence indicating imminent threats to the safety of everyone. These incidents represented a significant escalation of violence that required decisive action. As a result, the department authorized a facility-wide lock-in beginning on August 10th in order to conduct tactical search operations. These operations are an essential tool for restoring order, addressing security risks, and removing life-threatening contraband. Facility-wide lock-in was lifted on August 12th, following the completion of these operations. However, some housing areas remain secured beyond that date due to ongoing security concerns and continued acts of violence. These were targeted and necessary measures based on real-time assessment of risk. We fully recognize that lockdown impacts services, but I think we can all agree that we must, above all, maintain a safe environment for everyone in jails. Nonetheless, we do not take disruptions to services very lightly. Throughout this period, medical and mental health services continued without interruption. Other services were temporarily disrupted, but this was an unavoidable consequence of ensuring safety during a volatile and dangerous period within the facility. It is also important to underscore that the department has consistently fulfilled its obligation of transparency on this matter. Emergency lock-ins are documented and reported with detail, of the minimum standards impacted. The board has direct access to relevant notifications and 24-hour reports which provide timely updated on facility conditions. These reporting mechanisms are designed precisely so that oversight bodies such as the board can remain fully informed. The department does not resort to emergency lock-ins as a casual or without serious consideration. But when violence escalates to the level that we experience, the safety of the staff and the people in custody comes first. In those moments, inaction is not an option. The lock-ins that occurred at OBCC are based on the conditions at hand, executed with care, focused on keeping people safe and restoring order. While we welcome continuous dialogue with the board, the dialogue must rest on an accurate understanding of the events, correctional practices, and responsibilities we carry. We appreciate the opportunity to answer any questions.
Well, any board members have questions? I know I'd like to chime in to the response. Board Member Stasso.
Thank you. I think we have some data just looking at areas that were afforded recreation between August 1st and August 17th, and it looks like units received recreation 1 to 2 times over the course of that entire period in OBCC. I just am concerned about access to services in this facility. I don't know if it's related to these lockdowns or related to staffing issues, but I'm just wondering if you can speak to what DOC is doing to address that.
As I stated before, anytime there's a lock-in or a lockdown of a facility is based on security concerns and risk factors. In this case, I don't have the exact dates you're talking about, but in reference to the case you're talking about, we have the exact dates of what happened and what transpired to ensure that we can have dialogue to explain the reasonings why this happened. The dates you're talking about, I can, if you can give that information later on, we can follow up and answer those questions. But mostly in the majority of the concerns are security related. I'll give an example. In this case, the period in question began at 2100 hours on August 8th and ended at 0500 hours on August 13th. The data does not support a 5-day lock-in, just to show you that factor. During that time, there was 56 hours of available lockout time, 14 hours from August 9th to August 12th. August 8th, at approximately 2045, a slashing occurred in housing area 4. That was the reason for a search there. August 9th, at 0500, housing area 4 South was placed on lockdown. At 0833, slashings occurred in housing area 1 South. At 0932 hours, housing area of 1 South was on lockdown. At 1831, a stabbing attempt slashing occurred in housing area 5 South, resulting in an investigation, COD, a number investigation. At 2152, housing area 5 South was placed in lockdown pending investigation, removal people in custody, and search by CIB. Chief Lemon notified via email that the facility would remain on lockdown on August 10th, including 5 West. August 10th, 2157, OBCC was placed on facility lockdown until further notice for security concerns. Security Chief Lemon notified via email that the facility lockdown would remain effect August 10th through 12th. Housing area 5 South remains locked down for security purposes. Now I can give you information on what we found because of the information we had with these slashings. Tactical search, TSOs. TSOs during 0800 to 1200 hours, area search 5 North, 5 West, 3 North, 3 West, 1 North, 1 West, received 8 contraband weapons. 2, TSO durations 1600 to 1845, areas 4 lower, 6 lower, 7 lower, 8 lower, recoveries 1 contraband non-weapon. April 12th, TSO continued at the facility. TSO duration 0800 to 1040. Area search 2 upper, 5 upper, 5 lower, 6 upper, 8 upper. Recovered 3 contraband weapons, 3 contraband non-weapons. TSO duration 1600, 1800 hours. Area searched 1 lower, 2 lower, 3 lower, 3 upper, recoveries, 1 contraband weapon. So I'm trying to explain to you that the reasons for these are just to make sure that we can keep our employees and the people in custody safe. Truly, that is the main factor why we have lock-ins and lockdowns to prevent this. In this case, in totality of circumstances, this is an ongoing concern where there was multiple instances back to back to back. As we secured the lockdown, we let go, something else would happen. And those are all security risks that we're trying to prevent. Any issues or concerns happening to the employees of DOC, which work hard to ensure the safety of the personnel and to ensure once there's been a slashing or a stabbing, there is a weapon because somebody obviously got cut and the weapon gets passed around, we have to find it. Because if we don't find that weapon at that time, it's going to harm somebody else. And that's we err on the side of caution to make sure we can keep all of our PICs, of which we are responsible, and our employees safe.
Thank you. So it sounds like all of those weapons that you just described were recovered around August 12th. Is that right?
Yeah, depending on the time of each event.
So I guess I'm curious about then the 5 days following that, where only about 2 units received recreation. If you have a sense of why that would have happened, I would think that it would be sort of an important time to let people get outside.
I don't have the exact data of what you're talking about, but I can tell you there's various reasons why they wouldn't go out. I just explained some of the circumstances as to reasons why. Depending on the time of day, it could be security risk, it could be concerns with call outs and things of that nature that we have to adjust. But the reality is it is to our benefit to get them into rec because that causes problems in the facility itself. So I can't go in specifics into your matter. If you want us to address those, please, I welcome you sending that information to us to discuss later on.
Thank you.
Thank you. Just 1 second. There's some follow-up on this area that we'd like to address as well. But just to be clear, you stated that there was no 5-day lockdown?
Yes, the total facility 5-day lockdown.
Okay, but there was some confirmation from your staff of a 5-day lockdown in communicating out from the department?
I'm not certain what you're talking about. This is a 5-day lockdown.
Yes, Jasmine, a follow up on what notes we have.
Thank you, SDC Brahe. I think the concern from the board is that all of these lock-ins, whether 5 days, 3 days, is that it impacts the services, the mandated services to be provided to people in custody. I can read numbers with respect to the number of days recreation wasn't provided in 1 South. For the entire month of August, it was provided for 2 days. In 2 Southwest, 2 days, 4 South, 3 days, 5 Southwest, 3 days, 1 Southwest, 6 days, 2 South, 5 days, 3 South, 3 days, 4 Southwest, 3 days, Southwest, 5 days, and 5 South for 3 days. So I think the concern is that whether these lock-ins are caused by TSOs, while the board appreciates the importance of security concerns, absolutely. But the board also has standards with respect to providing recreation on a daily basis. And that, to my understanding, has not been suspended by EEO. So is there a plan from the department to provide these services in light of all the TSOs and in light of the staff shortages? Is there a plan? And is there a plan to ask for a variance from the board standards, which are still in effect? Which would put the board on notice of what standards, what mandated services are going to be impacted and what the department's plan is to provide those services to the people in custody.
Well, we will review our current processes as we do security protocols when it comes to acts of violence that require TSOs or lock-ins. We will be going back to review and see ways that we can ensure, as in the case I just expressed the past 5 days, where we can make sure that they are allowed the time to have recreation and programs. We at no time want to not afford them of those of the programs. In fact, it's important for us to give them those programs because it's beneficial to us. That is a happier and more well-rounded individual that doesn't really cause concerns when they don't get the things that are afforded to them. So we will be reviewing that as we go back. If you want to give further data on the exact date and time, but we can discuss that later on. I can present that to you. I don't have that information on me right now. But as far as review, we will review the process in general to make sure that we can afford those programs when possible, as long as it doesn't affect the safety of the personnel that work for us and also the PICs in custody.
Board Member Felipe?
Maybe this is more a clarification about our data. So what we have uncovered is that actually there could be moments that for a whole month, folks are actually getting only 3 hours or 3 days of programming. Is that what the data is showing?
The data that I just read was specific to recreation.
Recreation.
In certain housing areas.
But anyway, just on the recreation aspect, they may only have access to it 3 to 4, maybe 6 times a month. Is that what the data shows?
I can ask our AED of monitoring to speak more towards what the data is showing in terms of programming, but specifically regarding recreation, we know that it's not being afforded on a daily basis. And we don't have a plan from the department as to what they're going to do about that.
So the question to the department, I mean, you have incidents and challenges in some units. You have programming that actually could alleviate some of those challenges, and you're not using it. Why?
Excuse me, can you repeat that, sir?
I mean, you have incidents and challenges in some particular units, and you are withholding the ability to have even basic recreation in the places where you're having the most challenges. Why are you doing that?
Well, you're saying as if we're holding it for no actual purpose whatsoever. And I just advise you that we're going to take and review our concerns, security risks, and factors as far as when we provide them recreation specifically when we do have these instances. But I think it will be more, it would be beneficial for both parties if you could come to the facility, give us your concerns so we can review and go over them right there and then. I don't want to just second guess and answer questions with just information as words. There's the same thing. I was prepared to answer questions. That's what we were asked. I can be prepared to answer whatever questions you have, and then we can put a plan together to make sure going forward, we can walk in lockstep. The purpose of this whole meeting here is to ensure that the Board of Corrections and DOC work together to go forward. So if that's the case, then let's.
Well, I think the purpose of the meeting is for the Board of Corrections to ensure that you follow the standards. And on that note, programming seems to be important. And I want to hear from you why it's not that important.
So I think it'd be super helpful, ED, George Ellis, if you could share that data with us and we can happily take a full in-depth analysis of recreation at OBCC and we can follow up.
Sure, and I already sent a letter regarding this particular issue asking for what the department's plan is with respect to recreation. I haven't seen a response, but I'll send that again.
Right. So I think there's no doubt, right? There are like delays and challenges, but as the SDC said, there are like safety and security is paramount, but we don't want to negate people's mandated services and from them receiving programming. So I think there's a way for us to meet in the middle. If you sent it already, I'll check with my staff and we can cross-reference it with what we're seeing on the ground and follow up.
Yeah. And I tend to always believe that responsibility lies on all parts, and that is BOC as well. You know, we have been short-staffed in that area at OBCC, but now we're fully staffed in that area, so we can monitor more fully as to what is going on, so that we can address it with you in a more timely manner as well. So we do have full staffing now for OBCC to address the concerns of the minimum standards.
That would be greatly appreciated and help us at least work lockstep together to actually make sure that we improve the living conditions and environment of the PICs and our personnel that actually work in the facilities to make sure they're safe and sound. Thank you very much for that.
Okay, thank you. And now we'll move on to the status of implementation of DOI's 2024 recommendations for improved security measures concerning contraband, smuggling, in city jails.
Good afternoon. The 2024 report from DOI made 8 recommendations regarding contraband. The department partially accepted or fully accepted 7 of the 8 and rejected only 1. So I'll just go through, with your permission, the 8 and just say where we are on each of them. The first of the 8 provisions regarded putting lockers, staff lockers in front of the areas where the magnetometers are, where the front gate procedures are. We partially accepted this recommendation and partially rejected. We currently have 3 facilities where this framework is in place, West Facility, EMTC, and OBCC. We explored ways to try to make that happen for all facilities, but because of the borough-based jails program, we've talked about here and elsewhere that we don't have capital funding. So we were unable to make those structural changes to any of the other facilities. However, we have incorporated that architecture into all of the borough-based jails plans, as well as the outposts. So we can't really make any changes to our current structures because, again, of funding and just space and otherwise and capital improvements. However, we can do that and have implemented it for what will be built later on, and we have it in some facilities already. The second recommendation regarding placing K-9 officers at the front gates. The report indicated that hadn't been done robustly for a period of time. Since July of 2024, there is a front gate logbook that's maintained by the K-9 unit that's available for inspection. We have well over 20 K-9 units, including those that are utilized to support other investigative units like DOI or otherwise. And we have coverage, not all the time at every facility, but on a rotating basis at the facilities, at the front gate, checking for visitors, staff, and otherwise. They support other functions such as searches and things of that nature. And we enhance that, along with some other support staff like SIU to do those things. But with respect to the K-9s, we've improved the processes with that as far as putting them in place, at least on all tours on a regular basis. Again, not having somebody there 24 hours a day. This is, as you can imagine, a staffing crisis, not just for correction officers, but also the K-9 animals themselves. So it's a process that we're continuing to try to enhance. The third recommendation, which we did reject, involved the use of contractors or other law enforcement to serve as front gate staff. That, for a number of reasons, due to provisions in the city charter as well as collective bargaining, was not something that we could accept. It's just not feasible to have personnel who don't, report to the commissioner, who are not trained correctional staff to do that. So we did reject that at the time that the report was issued. The fourth provision or recommendation that they made, which we accepted, was that DOC staff are prohibited from bringing open or unsealed containers into the facilities, and that all liquid containers should be checked. This is and was department policy. So that's something that was implemented at the time the recommendation was made. Obviously we are always looking to enhance these procedures, so we will, make sure that that's being followed. The other recommendation, which we partially accepted, was the DOC should prohibit staff members from visiting unauthorized areas by requiring correction officers to swipe their ID cards when reporting to a housing area, and disciplining officers found on a post to which they were not assigned without justification. So our department policy already prohibits staff from going to unauthorized areas. The movement of staff is tracked through the logbook notations. And, as the board knows, we have a robust camera system that if there's any indication that officers are off post, we could always go back and check our Gen-Tech cameras or otherwise to see that. We are exploring, the use of ID cards. The borough-based jails and any new facilities that we open up will have this infrastructure in place to have ID swipes as we move throughout the facilities. However, that, along with the lock procedures to do on our current properties, would be a considerable capital expenditure to put scanning devices in, all of the different areas and, tie that up to door controls or otherwise. So it's just not something that, again, we were able to do in light of the borough-based jails, but we do anticipate that this will be the manner in which we operate once we open up new jails. The sixth recommendation regarded service providers and vendors. It asked, recommended that we do a robust review and background check of anyone, and that anyone that does not meet standards applicable to DOC staff as well, not be picked up as a service provider, and any service provider was formerly incarcerated at Rikers until at least 3 years after their release should not be brought in to provide services. We already do for all of our service providers and vendors a robust background check process. We were taking under consideration, I have to be honest with you, I made an inquiry and I don't know the status of it. The second part of that we don't bring on a service provider that has not been released from Rikers for at least 3 years or was released within the 3 years. So we will follow up with the board on that. That was something that we were taking under consideration. The seventh provision was persons in custody who have smuggled or possessed contraband in jail facilities in the past or are deemed high risk due to their gang affiliation should be rotated between different housing areas to minimize risk of inmate control of any housing area. We accepted that recommendation as that was part of our policy. So that's something that the department had and was doing at the time that the recommendations were made. And the last of the 8 was a classification system for persons in custody who attempt to bribe staff, similar to existing intended contraband recipients or red ID. The recommendation was also accepted as that was part of our policy at the time it was made, or shortly thereafter when the recommendations was made. And we often collaborate with the district attorneys on any of these issues with our Correction Intelligence Board to ensure that there's prosecution of staff or, anyone involved in bribery of any of our team.
Well, thank you. Any questions from the board? Yes, Board Member Stassi.
Thank you. Correct me if I'm mistaken here. My understanding was that at some point, the recommendation was for non-uniformed DOC personnel to be conducting the screenings, and then there was sort of a reiteration of that recommendation where it was external contractors. I'm just curious about whether there's any utility that you could see of non-uniformed personnel being the ones to conduct those searches, whether that would free up uniformed officers for other posts.
I'd have to go look back at our assessment, but I believe, that was not feasible for somewhat obvious reasons, because in the circumstance where someone might be bringing in some type of contraband, the need for an arrest might have to be necessary. So uniformed personnel that are specifically trained in correction practices, search procedures. I've been a civilian member of law enforcement agencies for, a quarter of a decade. I don't have the skill or training that uniformed officers do to do that. The contracting aspect was one thing, but, again, civilian personnel, even an employee of the department, don't necessarily receive that robust training. And there's just an experience with, law enforcement and uniformed officers that have quite candidly a capability that even, someone myself with experience does not have.
Okay, thank you.
Sir.
Following up on your point, but what about other officers that are not correctional officers? I mean, it's not unusual for jurisdictions to use law enforcement officers at entry points that are not part of the Department of Corrections in that jurisdiction.
Well, a couple of things. For the reason
We have many sheriff's offices across the nation.
Yeah, no, I mean, part of the problem is, again, the security of Rikers Island is by city charter and Department of Correction is delegated to the commissioner. The commissioner does not oversee those other law enforcement agencies. And, quite candidly also, there is a shortage of law enforcement officers throughout the city. The commissioner, police commissioner has testified about that rather robustly. I know the sheriff's office has also articulated something as well. So it's not like there's an abundance in any agency in law enforcement in the city or otherwise that has this personnel to spare.
But it will give you a very objective entry point.
I'm sorry?
It will give you a very safe, objective entry point, less likely to be influenced.
Well, we do, again, because we use Special Operations Division personnel, not personnel assigned to the facility, there is a bifurcation of the assignments. So, we do believe that the process is robust and efficient at the front gates. Could always be improved upon, but again, I don't know that bringing in any other law enforcement necessarily enhances that in any way. Or again, would they be available to do so?
One other recommendation that I don't think was discussed, but it did come up at a prior meeting, was that there was a recommendation to minimize the number of external pockets on officer uniforms that was issued in 2018 and then followed and then sort of changed in 2022. And I think there wasn't an explanation of why that sort of rule went away. I'm wondering if you can speak to that or if that would be something to re-implement.
I'm sorry, I can't, but we will bring that back. You're right. It was part of the previous recommendations I prepared for the 2024 ones, and that was not in there, but I remember us talking about it here. So we'll report back on that.
Okay, thank you.
You're welcome.
And then lastly, I think according to the DOI report, as of April of last year, there had not been any front gate searches with the K-9 unit in over a year. I was just curious about whether, with the expansion of the K-9 unit, there had been additional front gate searches to look for opiates.
Yes, regularly, especially since April of 25 is when this most robustly went into effect. I don't have statistics on that, but we do have the logbooks that we could refer back to. So yes, that's changed.
Okay, thank you. Just for the record, before we continue on, we are 2 hours into the meeting, and it looks like we may have about another hour and 15 minutes, just in my estimating time for the meeting, but we will continue. So now we'll go on to update regarding DOC's contraband testing protocols involving people in custody, visitors, and legal representatives.
So on this topic, we don't have prepared remarks because our policies and procedures have not changed. And I don't think this was something that we've spoken about recently, at least at any Board of Correction meeting. So the indication that there should be an update is, I'm not exactly sure what we're looking for. So I'll be happy to answer questions if there are specific questions related to that topic.
I think there were questions sent to the department on this. I do recall seeing regarding the contraband testing protocols, and we have several notices to the department on that, Jasmine.
Yeah, I think just by update, it's just a matter of what is the protocol, and can you share that with the board so that they can understand fully what process you're following?
Well, I think it depends on the circumstance and what type of contraband we're discussing. So I don't know if there's a focus that the department is looking at, the board is looking at.
We'll come back with more clarification on that. Okay. Thank you. Okay, so now we are to follow-up items. DOC response to the committee report and recommendations issued on July 8th, 2025 by BOC's ad hoc committee on 6A committee to review the utilization of DOC's work release program.
Well, good afternoon, members of the board. Francis Torres, First Deputy Commissioner at the department. We would like to start by not giving any open remarks, but rather be grateful for the opportunity to have met with us to discuss some recommendations, but also to allow us the opportunity to share what our processes are when we evaluate any of our sentenced persons in custody to be considered for a 6A release, keeping in mind and bearing in mind that it's not an early release program or a population reduction tool. We are grateful for the recommendations that were made by the board. We have conducted analysis and have done internal conversations. At this time, we're not taking the recommendations. We think that what we have outlined for ourselves and also the type of progress that we're making with the utilization of the 6A at this time is working for us. And what we mean by that is that in 2010, in 2023, we actually released 10 persons to the 6A program. In 2024, we released 44 individuals. And currently, as of last week, we have already released 44 and continue to do the exercise of analyzing all of the sentenced persons assigned to our care. Thank you.
Okay, we'll take questions now. Board Member Pitts?
Okay. Thank you, DC Torres. Of the 44 that have been released, I guess since July, when we last met.
44 for the entire year,
for-
for 2025.
Okay, so do we know how many have been released since we met in July?
I'll be more than happy to follow up and send them to you.
Okay, so, well, send to us also, please. How many of them were women?
Oh, sure. So what I will do is, after the meeting, we'll be more than happy to send you our internal report so
Okay.
that you have it.
And add to that, please, also, how many were mentally ill?
Sure,
Okay, thank you.
absolutely.
Board Member Stasso?
I appreciate your remarks, DC Torres, and I do just want to share that I feel disappointed that you're not going to take the recommendations. I think a lot of the recommendations we made were really geared towards making sure that old misbehavior was not sort of carrying undue weight in decision-making processes. I think, based on my experience of working in the jails, I don't think that additional time in custody makes people less likely to be violent in the future. I think we have a lot of data to suggest that it makes people more likely to be violent in the future. And so, with so many people nearing the end of city sentences, with the jails being as dangerous as they are, with the census being as high as it is, I would urge you to, consider finding ways to minimize how much we're thinking about old issues like failure to appear or, even additional charges in making these decisions about letting people serve the remainder of their sentence in the community. So just wanted to.
So Dr. Stossel, I don't want you to be disappointed, because the beauty about the dynamic between the DOC and the BOC is that our conversations are ongoing. And so just because we didn't accept the recommendations that were made in July does not negate the fact that we are not open to dialogue. We're always open to dialogue, and we always challenge ourselves internally.
Well, I'm going to just make a brief comment, then I'll go to Vice Chair Skip, and then on another topic area to Board Member Franco. I just wanted to say that your 6A release numbers from 23 to 24 and year to date, as Board Member Pitts has asked from what occurred from July, I think that even though the department chose not to accept the board's recommendations, you might have unofficially accepted some of these recommendations because these numbers, are increasing, in the 6A.
So let me just establish that in 2023, as a department, we released 10 to 6A. In 2024, as a department, we released 44.
Yes.
In 2025, at least until last week, we had already released 44.
I understand.
Right? And so what I don't have at my hand right now is a breakdown to give Board Member Pitts how many we released in July. And so in submitting to you, I plan to submit the comprehensive report that we have.
I'm actually, commending the cooperation.
Sure, but I will tell you this, it's ongoing. I know that currently the commissioner is reviewing at least one candidate that we presented to her yesterday.
Right. The results are leading to more 6A releases at this moment. And so I applaud that, and I applaud, the committee chair's work in this area, Board Member Stossel. So that is much appreciated. So now we'll go to a question from Vice Chair Skipper.
Thank you, Chair Sampson. Hey, First Step Torres. I just would be, can you guys hear me?
Yes.
Okay, just wanted to make sure. I just would be curious as to know why certain recommendations were not accepted, and think it would be really helpful in the spirit of both the board and DLC working hand in hand, as Mr. Friday just said it in lockstep. If you got back to us with why some of our recommendations were not accepted, so that, if possible, we can take a look at them and maybe rework or reframe them, because at the end of the day, we both need to come to a happy medium
So Vice
in
Chair,
6A and how it's utilized.
sure, Vice Chair Skip, we can do two things. Either have a different meeting, meaning the same people that met before, when we had the teams and the telephone calls, or we can certainly provide you with a written response. We defer to you.
I think either one is great. A written response is great. Just like, delineating why you felt that this was not feasible, these recommendations were not
Sure.
feasible, which will give us a good starting point. Thank
You're
you so
welcome, ma'am.
much.
Okay, thank you. We'll follow up on that
Sure.
with you. We just have from Board Member Franco, he wants a question on programs, which is off topic for now.
This is very quick. I haven't seen you in a while, Torres, and
Oh, you're gonna nail me now, Franco.
I know you have dedicated the last 10 years to education, and I want to hear, how was it that we achieved 63 young people graduating from Friends of Island Academy? And what are you doing with those 63 people now that you've got that done?
So the kudos really go to a larger group, and you know how it goes. First of all, the Department of Education or New York City Public Schools, because they are the ones who are mandated to provide instruction. But I think I need to really give the kudos to our department's educational services unit, our legal team, the law department, New York City Law Department, and also the DOE's legal team. We have been collaborating for the last year to ensure that we adhere not just to the mandates as they are established by Hanbury, but also challenging ourselves and thinking outside the box. And so last year was very successful because the DOE was able to embrace some of our recommendations. We also made internal changes to our operation. We emphasize what you've known already for a couple of years, probably strongly since 2022, the success of having those dedicated schoolhouses, but also ensuring that through their per session, we were able to obtain additional services in the afternoon to include the adult education component. The DOE has continued to work. We're looking to this new academic year. The 63 individuals, emerging adults and adults that completed, that is something that the DOE continues to check. You know too well that there's no limitation just because you're 21 in them not affording services. But for the summer, we challenged some of the kids. We actually had them in our summer job program. We continue to have them assigned to other workforce development components as part of career and technical education.
Keep the good work.
We're trying.
Talk to us about college next time.
All right. Thank you, Franco.
Okay, thank you. We'll go to the next item for the department,
Sure.
which is status update regarding provision of mandated services in RESH, given staff reductions to help service the RESH annex.
Sure. For that one, I do have remarks, if I may, please.
Thank you.
And I'll skip the formal introduction. I'm here to discuss the provision of mandated services at RESH in light of questions raised by the board regarding staffing and the RESH annex. Let me begin by providing a point of clarification. It has been suggested that staff were reassigned from RESH to RESH Annex to support operations at RESH Annex when it was opened. That is simply not accurate. The department did not move staff out of RESH for this purpose. In fact, the annex was staffed entirely by probationary correction officers with specific mentorship and guidance by selected assistant deputy wardens. It is important to be clear about it because misinformation underestimates a fact-based discussion on how services are being delivered. With that understanding in place, I want to turn to mandated services. The department recognizes the significance of these services, not only because they are required by minimum standards, but because they directly affect the well-being and dignity of those who are assigned to our care. To ensure we had a clear picture, we reviewed grievances from April through August. We found that the overall number of grievances related to minimum standards remained relatively steady. Many of the grievances that were submitted regarding minimum services were specifically related to recreation. April, we had 16 grievances. May, we had 17. June, we had 9. July, 10. And in August, 7. We recognize that recreation is a consistent concern, and that is one of the areas we are focusing on. The department is working to strengthen access and ensure consistency because we understand the importance of recreation to both physical and mental health. Although we received very few complaints related to uniform and linen exchange, our ongoing internal assessments found that uniform exchange remained strong at roughly 85%, compliance with minimum standards, whereas linen exchange stands at 70%. That is below where we want to be. And we are actively evaluating ways to improve consistency in that specific area. Catholic, Jewish, Muslim, and Protestant services are being provided at RESH, and the department tracks sessions and participation rates for these services. Grievances related to faith-based services remain low, reflecting that they are being delivered as required. April 2, grievances, May 1, June 0, July 0, August 1. We recognize that these services are not optional, they are fundamental. While we can point to areas of stability and progress, we also acknowledge where challenges remain, and we are committed to addressing them heads on. The department welcomes the opportunity to continue dialogue with the board as we share a common responsibility to ensure that mandated services are consistently delivered. Thank you.
Thank you. Board Member Pitts.
Yes, First Deputy Commissioner Torres. We know that grievances is one thing and percentage of participation is another. For those areas that you mentioned, the number of grievances, would you later on be able to tell us what the percentage of participation was?
Phenomenal question, certainly.
Thank you.
Jasmine, Executive Director.
Hello, I just have a quick question. So how many of the probationary COs are still employed with DOC and are they assigned in the annex?
So would you mind if I were to do a follow-up? Because we would have to look at their assignments throughout the department. I am happy to share with you that the probationary officers assigned to RESH Annex have remained. And so I think that the combination of direct mentorship, direct guidance by the two selected assistant deputy wardens and by the captains that were assigned there has worked to our advantage. But we'll be more than happy to share where we are with that group.
Board Member Pitts?
I just want to take the opportunity to give kudos to the department for using new staff for new ideas. That's the way to do it, in my opinion.
Thank you. Thank you, ma'am.
Any other questions for the department? Well, thank you.
Thank you.
Much appreciated. Now, I'll ask the board if a recess is needed. If not, we will continue. We will go next to PIC comments, which PIC comments, there's 17, and that will take about 30 to 35 minutes. And then we go to CHS updates. So take a recess. Okay, so I'll need a motion to take a excuse me 1 second. Okay, so is there a motion for a 5-minute recess? The motion? Not sec, I need one motion first.
Motion.
In a second? And, okay, all in favor of a 5-minute recess?
Yeah.
5-minute recess.
both substance use and mental health needs, but do not require MO or PACE level of care. The GATE units were designed to leverage the therapeutic community model to foster peer support opportunities and to provide group-based relapse prevention programs. Currently, there is one GATE unit operating in OBCC with a census of 47 individuals. It's important to note that CHS provides mental health and substance use services to every person in custody who needs them, regardless of where the person is housed. CHS's opioid treatment program, called KEEP, treats patients in every jail facility and every housing type, providing methadone and buprenorphine maintenance to patients while they are in jail and providing linkages to community-based treatment and harm reduction services to patients reentering their communities. Most patients who have mental health and substance use needs can be appropriately treated through an outpatient clinic-based model like that of general population housing, while more acute patients may benefit from the increased patient-provider engagement and enhanced treatment available on a therapeutic housing unit. In OBCC's GATE unit, CHS staff, including licensed substance use counselors, KEEP counselors, and creative arts therapists, facilitate various group therapy sessions for substance use treatment over the course of the day. The GATE unit is modeled to be a voluntary unit that, like sober living communities, requires patients to engage in addiction treatments and maintain sobriety while on the unit. And as such, typically has very high engagement by patients who are housed on these units. In order to meet the evolving clinical needs of our patient population, we are continually assessing the therapeutic housing model, particularly given the increased census island-wide. GATE has historically served patients who tend to be more clinically stable. In early June 2025, the department determined that the GATE unit in RMSC would need to temporarily close due to the increasing census and the need to maximize the use of all available beds. As such, patients in RMSC who were previously housed in GATE were transferred to other GP housing areas in RMSC in mid-June, and South 5A was repurposed as a GP unit for women. Following the closure of the RMSC GATE unit, CHS leadership within the facility collaborated with DOC programs to continue to provide therapeutic groups for former GATE patients in that facility. Since June, patients formerly housed in RMSC's GATE unit have been brought to the gym or school twice weekly, where they continue to receive targeted therapeutic group interventions, such as group meditation. Of the 24 patients who were housed in RMSC GATE at the time that it temporarily closed, there remain about 18 individuals who continue to participate in this therapeutic programming. That's a brief overview.
Okay, thank you. Are you taking questions at this time? Or
Sure.
is there another part of your presentation?
Happy to take questions or defer to.
No, happy to take questions. Deputy Commissioner James Saunders, Health Affairs, Quality and Compliance.
Okay.
Happy to take any questions about the GATE.
Any board members' questions regarding the GATE program? Board Member Stossel?
Thank you, guys. I completely understand the, competitive bed situation in RMSC right now. I'm just curious if, the situation changes, the census goes down. Is this something that CHS and DOC are interested in trying to implement again at some point if there are enough beds and enough motivated individuals to fill a unit like this?
Yes.
Yeah, I think our understanding is that it's a temporary closure, and it's our expectation. Hope is for it to reopen.
Thank you.
Yeah.
Okay, any other questions from any board? Oh, yes, Board Vice Chair Skipper is waving a hand. Go ahead, Vice Chair. We cannot hear you at this time.
Can you hear me now?
Yes, we can.
Okay, so thank you for this presentation. I understand you to say that you've been moving PICs who were involved in GATE to either the school or I forgot the other location at least twice a week to receive some of the services that Gate provided. Is this up to the level of services that Gate had when it was its own separate housing area? And if not, how do you propose to go back to that level of services? Because I believe Gate is a very necessary program.
Yeah, it's not the same. It's a modified version of it, and while it does,
I totally get the idea about the living with like-minded people in a therapeutic atmosphere. I do understand that, but like there are more aspects of the program, I believe, that you can retain, and you cannot retain it if you're only affording people 2 days a week with this. So what is your plan to like up services, not to the level where they're all living together, because I understand the challenges, but services can still be ramped up. And is there a plan for this?
I will just jump into, as I do understand that there's been conversation about other sober living resources within the jail system with programs, colleagues at DOC. So this is one type of treatment program for Zach Rosner, Chief of Medicine, and I do oversee the opioid treatment program. There are a broad range of other substance use treatment services and counseling that exist in the jails within our substance use treatment program on the medical services. So that can be for people who use substances like opioids, but also alcohol use disorder. And so this is one program within a broad range of other types of services.
Hi, James Saunders, Deputy Commissioner of Health Affairs. So I just want to reiterate what my colleagues at CHS have said, but also note that our conversations about reopening this program continue. Of course, as you know, this entire endeavor arose because of the census crisis that we experienced. We came to the board a few months ago and weeks ago asking for variance to increase certain bed counts. And so we still have remaining approximately 400 state-ready individuals, so we are still in the midst of that crisis. When that abates, we hope, and we'll certainly continue to move forward on the path of reopening Gate.
Well, thank you for the presentation. Just off topic, but another topic that's been relevant to this board regarding bed space at Bellevue and Elmhurst being open. I know that was an outstanding question. And was looking for the findings of the results of on that. Could someone address that?
Elmhurst has.
Well, Bellevue, at the Bellevue unit.
So you're talking about the outposted therapeutic housing unit, also known as the Bellevue second floor jail? Is there a question about that in particular?
Yes.
Okay.
It's regarding, there was a new unit that you were supposed to be opening and you were waiting for certifications of some sort.
Okay.
I'm just trying to see where we are on that.
Yeah, so we continue to have conversations with our partners, CHS and the city, regarding the OTHU, the Bellevue outpost. There's still processes going on with certification. The SCOC has to certify it as a jail. There has to be, staffing plans and otherwise. This is all ongoing work, but the SCOC has not, gotten to the point where the work is done sufficiently to certify it as being.
Is there a timeline that we're looking at?
Not specifically, but we've had conversations with the mayor's offices, our deputy mayors. It's ongoing in the city. I can't give a specific timeline, but we just had a meeting this past couple of weeks ago with SCOC and all of our partners to kind of get an idea of what that would be.
Yeah. And I raise it, and I will continue to raise it, from this board chair, because mental health is just one of those issues that the city and our society faces. And so I really would like to look at some timeline that this matter will be addressed.
Yeah, that's not exclusive, just for the record, that's not exclusive to mental health. We're still going to maintain, our mental health units and otherwise on the island. And in our current facilities, that's also a medical facility as well for someone with longer term care needs.
Okay. Board Member Pitts?
Am I mistaken? I thought I read a teletype recently that staff was transferred to Bellevue for the dedicated unit.
I think it was very limited. Yeah, it was just fire watch. So,
Thank you.
yeah, not housing area stuff.
Okay, thank you. Yeah, it's not my intention to catch you off guard with that question, but it's something that came across my desk, and I will continue to ask that particular.
Yeah, no, we understand. It's an evolving, such situation as we continue to work towards
All right, well,
opening.
thank you. No other questions. Thank you. Now we'll go to PIC comments. Yeah. Okay, right now we will go to PIC comments. And these are pre-recorded anonymous public comments from people in custody, 17 comments. Redacted comments have been shared with the department. All comments associated with a facility have been assigned to the BOC facility monitor and have either been resolved or are being addressed. So.
Closed captioning is provided for viewer convenience. However, the accuracy of machine-generated captions may vary based on audio quality and speaker cadence. The Board of Correction does not guarantee the accuracy or completeness of the captions. To ensure the safety and protection of individuals using the people in custody comment line, names and inmate numbers have been withheld.
Hi, my name is in EMTC C76. I have asthma and I currently have a broken rib with a cheek tailbone. And they have me in a regular housing area, and I got hit the other day by somebody, and they did nothing about it. They moved me to a housing area where I could barely breathe. They're doing nothing about it. I appreciate it very much if you can look into it. And like I said, I have a broken rib and a tailbone. I should be in some kind of medical housing or something right now. This was 3 weeks ago. Harlem Hospital told me I had a broken rib and a chipped tailbone. And I let these people know, and they are doing nothing about it. I believe this is the second time I'm calling this hotline. Please, can you do something about it? Thank you very much. Bye.
The caller has hung up.
Yes. Hello. My name is here at Otis Batum Correctional Center, One Upper. I'm a part of the mental health census here at One Upper. Not sure what to say, but I'll just let it all be known. For over 9 months, we have been living in a heavy lice infestation unit where we don't have we don't have any movement because we're mental health. We was told that we don't have no movement, no free movement. So we're mostly stuck in the dorms 24/7. So we're stuck around these vermin that's in the showers, on the toilets, that lives inside of our beds and on our sheets every day. And we can't get down to the clinic because they like to overlook us or not accommodate us like they accommodate the GP and regular others here at Rikers Island, which is very strange. We have a hard time fending for ourselves because of our mental illnesses, and DOC fails to accommodate us whenever we tell them, hey, for me, for instance, I've been getting bit by lice all to the point where half of my body is covered in bugs, and they're sucking my blood, and I'm asking to go down to the clinic to get treatment, and I just get ran around all day. Captain that tells me, oh, just jump in the shower. But that doesn't negate the fact that they're living on my sheets. It doesn't negate the fact that they're living in my beds. It doesn't negate the fact that they're living in my shoes. I can't get away from them. So I'm going to jump in the shower, get clean, just to jump back into a lice-infested area where more than 50 people are going through the same thing every single day. Medical doesn't come up here to do sick call appointments. I was told to call 614. I waited on the phone for 45 minutes. Sometimes they don't even answer, where they're misusing and abusing their own policy to not do their job. Where the only way I can get to the clinic is if a DOC personnel escorts me at the end of the day. It doesn't matter if I'm on the list or not. Because we don't have free movement, somebody has to escort me to that's about it. And also, medical doctor also has been turning me around with. Yeah, hello. My name is OBCC. Yeah, I would like to let you know I'm at One Upper. We've been being denied a chance to go to sick hall heavily every time I've been trying to get down to there, because it comes to my attention that the clinic here, the New York City Health and Hospital Clinic here, is still doing the all sick call close out thing from the last lawsuit that happened in Legal Aid Society versus New York City Health and Hospitals in 2024. Yeah, they're still doing that, where we're directed, like me, the person in custody is directed to call 614. You call 614, and they promise that they put us on the list. Next thing you know, no officer comes around to pick us up. And then, they get to say that they get to close out their decision, as in that we was never produced. It's not our fault. Second, the OC knows that One Upper has been suffering from a heavy lice infestation that needs medical treatment. To properly kill lice and treat lice, you need proper medical treatment and chemicals to do it. But the officers keep telling us that they don't like to do their job, and they don't want to do their job, and we're making it too hard for them, and they just find reasons to be lazy and get around it. So they never produce us to medical, so nobody has to do their job. But it's still going on. It's really bad. I have lice on me right now. It's itching. I'm very itchy. I couldn't go down to medical today because the officer swore that I wasn't on a list, even though I called 614 on a recorded line and was promised that I was. They do this to us every day. Did I forget to mention that I'm mentally ill? I'm part of the MO, population here at Rikers Island. So I have a serious mental illness, and they still don't want to help us. They still don't want to accommodate for us. They still don't want to give us effective treatment, cream, to kill the lice and treat the lice. They don't want to give us clean beds because I've been telling them and everybody that I know, 311 and the Board of Corrections, that the lice live inside our beds. So we're being forced to live on side of these beds that have lice. And they know it, and no one will help us. That really sums it up. We being denied medical treatment, We have lice. Nobody's helping us in rec. Rec has not been coming around here for the last month, from June to July. Rec.
Hello, good day. My name is, I'm currently incarcerated here on Rikers Island. I'm in 17 Lower A side. I am in the West Facilities part of the jail. It's 9:30 a.m. July 9th. I have 4 officers standing around doing nothing. I also have 1 officer on post sleeping, which is the male officer. She has not delivered mail in none of these houses in 7 days. Okay? They're constantly saying that they don't have enough officers. We need something done about this ASAP, please. That's my message. Please, can y'all come here and get this shit in order? This shit is out of order. Thank you. Have a good day.
The caller has hung up.
Yes, good morning. My name is, today is July 9th at approximately 9:35 in the morning. I have 4 correctional officers sitting in the bubble doing nothing. I also have another correctional officer on the floor sleeping, which is the male officer. That we haven't received our meal within a week. We are living in inhumane conditions. 4 our sinks don't work. Our stop sink doesn't even work. And one of our toilets continuously have feces in it. We have reported this over numerous times, and nobody has continued to do nothing about the situation. Thank you.
The caller has hung up.
Hello, I'm on Rikers Island. I'm in West Facilities. It's about 9:40 a.m. It's July 9th. We have been in 17 Lower A side without any exchange of pans and uniforms for multiple weeks. Not just 1 week, for multiple weeks. And y'all, please pay us a visit. Please pay us a visit. Our bathroom is disgusting. Sinks are not working. The slop sinks are not working. We're washing our clothes out in the sinks. We haven't had exchange of linen. Well, we had exchange of linen. We haven't had exchange of pans, our clothing, in multiple weeks. Please, multiple toilets are not working. Please send somebody over here to this dorm. Please, thank you.
The caller has hung up.
Hello, my name is, my booking case. I'm calling for West Facilities on Rikers Island. Last time we would deliver our mail was Wednesday at 5:10 p.m. Last Wednesday. They're not delivering the mail. The mail is supposed to be delivered 7 days a week, but however, they're delivering tickets every day. They have an officer that delivers tickets every day, and they do hearings every day, but they're not delivering the federal mail every day. Please see to it that they deliver us our mail. Please come and check the conditions of our bathrooms. Our living conditions are strange. Please do something about it. Thank you.
The caller has hung up.
Hello, my name is because I'm on Rikers Island, West Facility 18 for B, and I asked the social service worker for updated web plan, and she denied my help. She denied helping me, and I asked to speak to a supervisor, and I spoke clearly and concise to her, and she acted like she didn't understand what I'm saying.
The caller has hung up.
Hello, my name is. I'm currently incarcerated under the alias name. Booking case number is 3. I'm currently incarcerated for B as in boy and cell number 3. I'm a transgender female housed in GRVC. However, today on the 24th of July, it is now 9:04. Institutional lockout is at 8 a.m. and I am still locked in my cell because there is no officer on the floor. We did have an officer 5 to 7 breakfast, but institutional lock-in is at 7, institutional lockout is at 8. Now there's no officer on the floor, and we are currently locked in ourselves, and I'm not able to get out and do the things that I normally would do in the mornings, like take a shower or call my family on the phone. I'm currently using the tablet. I'm hoping that you guys can hear me because I normally have issues when I speak to my family from the tablet because the signal is horrible here in my cell. So yes, I'm calling because this has become a pattern. I spoke with a captain on, I believe that was Saturday or Sunday, and because, like I said, this is a pattern. I believe on Saturday we didn't get out till about 10:30 a.m. when institutional lockout is at 8 a.m. And when I spoke to the captain, it was just offhandedly responded that, well, we didn't have staff. So hopefully this message can ring the alarm to the people who do scheduling here so that we can have enough officers so that we can get locked out at 8 so that we can get locked back in at 3 on time, like we did at 7. Thank you.
The caller has hung up.
Yes, good morning. My name is. Today is July 9th at approximately 9:35 in the morning. I have 4 correctional officers sitting in the bubble doing nothing. I also have another correctional officer on the floor sleeping, which is a male officer. That we haven't received our meal within a week. We are living in inhumane conditions. 4 our sinks don't work. Our stop sink doesn't even work. And one of our toilets continuously have feces in it. We have reported this over numerous times, and nobody has continued to do nothing about the situation. Thank you.
The caller has hung up.
Yeah, my booking number is. I didn't receive none of my commissary they gave me, and they're not treating me right in here. You know what I mean? Curse at you, do all that. You know what I mean? I've been here already since the 30th. And Rosie, and they moved me from over there, from the hospital. I come over here, they ain't giving my commissary yet. And I'm hungry, I want my commissary. Could you do something for me, please? Yeah.
The caller has hung up.
Hello, my name is Wilson K. I'm calling because I was denied medical attention by staff in West Facility, Rikers Island, and no apparent reason.
Hi, my name is Dee. I am currently housed in Rose M. Singer Center, building number 5, cell number. I was just recently moved from building number 6 to building number 5. And due to the amount of 311 complaints that I put in, I feel as if I'm being retaliated against by officers and staff by not even being on the count sheet. I'm not on the alpha sheet. I'm nowhere in the system. No programs can find me in the system. My family can't find me in the system. I need to get my attorney. I'm still in segregated confinement. I haven't received any outdoor programs since May of 2024, which I did not get credit from my OSHA. The conditions in building number 5 are something similar to building number 6, but except the mold in the bathroom in building number 5 is really, really bad. I mean, the entire bathroom wall and ceiling is completely black. I'm having difficulty breathing. That's probably why I make my voice sound a little grassy. At nighttime, I cough a lot and very shortness of breath when it's time to go to bed, or while in the shower, shortness of breath, those sort of things. So I guess I'm calling today because since the men have been moving into Rose M. Singer Center, the women have been crammed into cells, 50 women filling up the cell area at a time with absolutely limited movement, and this includes for consultation visits. We have had consultation visits missing. I've had consultation visits rescheduled. I've had doctor's appointments rescheduled. I've been injured. I fell down the steps in building number 6 because the stairwell was wet because there was a leak. The leak from the ceiling shorted out the exit sign, the light on the exit sign in building number 6, so the stairwell was completely wet. So there was multiple leaks in building 6. That is leaking on electrical stuff, which makes it really dangerous for detainees. This is not a suitable living area. I don't think anyone thought it through. You have shower curtains. The officers sit right in front of the shower curtains. There's no privacy for women when you're taking a shower. And it's almost as if everyone's hands are tied. I don't know what the outcome of this message will be, but women are screaming for help. Women are screaming for help, and we need to be heard. Good afternoon. My name is booking case number. I'm housed at Rose M. Singer Center, building number 5. I am calling to place this testimony on behalf of myself and other detainees concerning the law library. I've continuously put in grievances, complaints, and called Board of Corrections concerning the law library. This law library here in Rose M. Singer for the females is an inadequate one. So today there was an issue that arose where the new coordinator refused to help detainees after they sat in the law library for approximately 45 minutes waiting for her with her door closed. Basic minimum standards state that we get 2 hours. I don't think that it's fair. I don't think that it's appropriate, and I think it's very disrespectful and unhelpful for detainees that's trying to help fight their criminal case, civil cases, or whatever cases they help with. The law library is, again, a basic minimum standard. Officer badge number 4 was asked to cut on her camera when the law library coordinator decided to get hostile, yell, and curse. Officer refused. I asked for a captain. A captain was provided. The captain agreed. Captain Fulton, again, refused to document any of these things onto her camera, but made us leave the law library after just 45 minutes. All 4 detainees was not allowed to get any assistance from the law library today, August 13th, 2025. The ongoing problems with the law library is not helpful for anyone that's trying to save their own lives, help assist fight their case, or anything else. This is an inadequate law library. You have 1 kiosk. There's 1 Chromebook that doesn't.
Good morning. We have yet to have in building 18A upper and lower, 17A upper and lower, 19A upper and lower. We have had no rec for the past 2 days. Tension will be built high. Areas much needed, and gentlemen exercise here every day. We no direct or no church. We have also talked to the deputy and the captain on duty as of 11:05, which was the initial incident, 11 o'clock. The deputy says she wasn't able to do so. She doesn't have enough officers. The captain that was with her says she's not given no rec, period. This is a liability to inmates as well. Thank you.
The caller has hung up.
Hello, good afternoon. My name is
again, I'm calling because since the transition from EMTC, which is known as Big Field In, to RMSC, which is Rosemary Singer Center, it's been a lot of, miscommunications and stuff like that, and a lot of things that has been going on that we barely even get our bare minimum over here. But that's another story. I'm calling because I recently turned my tablet in because my tablet was frozen on the Securus loading part, and it wouldn't get past that part, turn on fully. And it just kept doing that, and I tried to turn it on and turn it off, and maybe thought that would situate the problem. That didn't situate the problem. An officer in the bubble, she also seen that my tablet was acting up. She tried to put it on the charger and thought that maybe we sit on the charger for a little while, that may fix it. No, that didn't fix it. I ended up turning my tablet into the officer that comes around and give out tablets and collect tablets. And she came here about a month ago wanting to get my tablet because I put in a ticket letting her know that my jack part was messed up. I could not make calls on it, and that's what I really wanted it for, besides, any other perks on there. I decided not to give her my tablet because she told me it would take a month or maybe more just to get my tablet back. So I kept my tablet. And in the near future, my tablet just started not working. Like I said, it was freezing up as I turned it on the Securus part and wouldn't go past that. Then it started saying something like, "Oh, put in your password to access the Android," something. I'm not sure. It was displaying another message. I don't know how that message ended up getting displayed. Didn't have no problems or basically I did nothing to this tablet at all. Didn't let nobody hold my tablet, no nothing. She came back today. The lady that, the officer that gives out tablets to take the tablet said that she returned it to Securus, showed Securus, and the Securus people are saying that I tried to hack the tablet, which is completely false. Never tried to hack the tablet, not once. Never even let somebody hold my tablet. It just stopped working. As cheap as these tablets are that they saying that they are, and you could just drop it in, I don't see how they could think or possibly, believe that somebody tried to hack it. Again, like I said, she gave it to them, and they said that I tried to hack it, basically saying that I guess I can't get another tablet. So I'm trying to see how can I go about, getting.
Viewer discretion advised. This video contains content that may be considered sexual or sensitive in nature.
My name is John. My ID number is... I'm in GRVC 13B in the mental health unit. I'm calling to ask for protection against it. You have sex with 2 mentally ill patients in a blue door with no camera facing it, or in the shower area where there's no cameras there, especially when the lights is out. And then she used the 2 inmates to beat up the mentally ill when the mentally ill is having mentally ill episodes. I'm asking for value to be removed from away from the mentally ill. I'm asking to press charges because had these same two inmates try to attack me on Saturday at 2 o'clock by the phone. And then the mental health staff was at my door on Saturday, and the inmate kept coming, beating on my door, talking about he's going to beat me up. And then when I came out at 2 o'clock, they had another inmate try to attack me with a weapon. And I'm asking for to be ready to use chemical spray on me while the inmates attack me. And I'm asking for that to be removed away from the mentally ill. I'm asking for protection against this. And I'm asking for surveillance cameras to face the blue door where they have sex at in the blue door. And I'm asking for camera areas to face the shower area where they have sex at by the shower area. And they have sex in the blue door. And the only thing behind the blue door is a hot pot. Okay? And I'm willing to testify to everything. Now today, August 25th, today was August 25th, 2025 at 11:51 a.m. Val was at the police station playing loud music, disturbing the mentally ill inmate. And then her and the mentally ill inmates almost came to blows to fight with each other. And then it was a mental health staff on the floor too. On the floor, witnessed the incident. And the surveillance camera witnessed the incident. Okay? It needs to be removed away from the mentally ill. I'm asking for protection against and I'm asking for values to be removed away from the mentally ill. And I'll be looking for the Board of Correction meeting, and I will call back again tomorrow morning. And I'm asking for values to be removed away from the mentally ill. And she has sex in the blue door where there's no camera facing it, or she has sex in the shower area where there's no camera facing it. And I'm asking for surveillance cameras to face the blue door, and I'm asking surveillance camera to face the shower with values to image that she used to beat people up. Thank you. I will call back tomorrow morning.
The caller has hung up.
Okay, thank you for the PIC comments. We will now hear comments from the public. But before we get started with comments from the public, I'd ask that comments concerning access to counsel be limited, since we did have a presentation on that, and there is follow-up on that. I think that we're pretty much on course with that. So that's the only area that I asked that it be limited comments on. So Jasmine will now read the names for those in that area.
First, we have Jennifer Parrish, followed by Justina Ruzwinski.
Good afternoon, everyone. My name is Jennifer Parrish. I work at the Urban Justice Center Mental Health Project, and I'm a member of the Jails Action Coalition and the Halt Solitary campaign. And I'm here to urge the board to focus its attention on one of the most vulnerable population in the jails, and that's people with mental health treatment needs. There's real urgency for doing that, and I think it's quite clear. This population is 22% of the jails. We're talking about people who are diagnosed with schizophrenia, schizoaffective disorder, major depression, bipolar disorder, and other disorders that affect their functioning. They need intensive treatment in the jails. We know that this population is also subjected to involuntary lock-in more than others. You heard that not only at previous Board of Correction meetings, but also your own findings showed that there were mental observation units where this is still happening, even after the Department of Correction is supposed to have told its staff not to do this. We also know that the 3 most recent deaths all involve people with mental health treatment needs. And Ardit Bila was in a PACE unit. This is the place where you're supposed to be able to get the highest level of care, and yet that's where he died. And that's in addition to the 9 people, at least 9 other people who've had mental health concerns who've died by suicide or otherwise since 2022. So this demands your immediate focused attention. It's heartbreaking to me that the quality of care in the jails has deteriorated to this point, especially because at one point we had PACE units that Correctional Health Services and Department of Correction were able to operate in a way that provided quality treatment for the people there and was actually recognized by both agencies as being one of the units that function most effectively. It's clearly deteriorated. How can it be that Ardit Bila was in a PACE unit where they're supposed to have a registered nurse, a psychiatric nurse practitioner, a mental health clinician, 3 mental health treatment aides, among other mental health staff, and yet he was described as being found with feces on his body and left in his cell for days? Clearly, there's a problem in those jails, in those units. I don't know why it was that someone could go that long in those conditions, but I do know that this happened more than a decade ago with Bradley Ballard. And at that point, that led to some of the changes that happened, getting rid of the for-profit company that was providing mental health treatment. But clearly, there are other issues related to the power that Department of Correction has on these units. There should be a way for the mental health staff to be having responsibility and authority for making sure that the care that's provided on those units is actual mental health treatment and not torture and not the horrendous conditions that we're hearing about now. This should be a priority for the committee that's looking at the mental health standards. Those mental health standards haven't been updated since they were adopted in 1985. So I hope that you will make that a priority and consult with outside experts, people who've been formerly incarcerated, and other advocates, including the Jails Action Coalition and the Halt Solitary campaign. Thank you.
Thank you. Justina Rzwinski, followed by Tamara Begel.
Good afternoon. Thank you for allowing me the opportunity to testify. My name is Justina Rosinski, and from December 2023 to September 2024, I served as the clinical supervisor on Rikers Island, specifically in the PACE unit where 29-year-old Mr. Ardit Bila was recently found dead. PACE units are supposed to represent the highest level of mental health care on Rikers. They have mental health staff, treatment aides, nurses, clinicians, psych NPs, clinical supervisor, and the unit is smaller than the other units. And still, this happened. Mr. Ardit was found covered in feces in a setting that was supposed to help him. And I personally witnessed people being deadlocked on PACE, confined to their cells around the clock, and denied basic human rights. DOC continues to deny that this practice occurs, but I saw it with my own eyes as well as you did. In the past 2 weeks, 3 people have died on Rikers Island: Ardit Bila, Carlos Cruz, and Jimmy Avila. 1 captain and 2 officers have been suspended, but that is not enough. So I urge the board to conduct regular and unannounced visits to units like PACE. During your report on June 23 to 2025 of the lock-in and lockout procedures, you toured 27 GP houses, 15 MOUs, 7 PC houses, 1 city sentence unit, but no PACE units. And this is where this occurred. Also, I would like to bring up the fact that there are no DOC programming for patients on the mental health unit. The only groups that they do receive is through CHS. They don't also have any access to GED programs. DOC says that every person in custody on Rikers Island has access to these services, but not the patients on the mental health units in GRVC. So I would really like for the board to look into this, because the patients on these units are constantly bored all day. They're staying in the units. They do go to recreation, but that is not every day. And as I stated, they only receive a group from CHS. Thank you.
Thank you. Tamara Begel, followed by Chaplain Dr. Victoria A. Phillips.
Good morning, or good afternoon. My name is Tamara Begel, and I'm an independent mental health care, and justice advocate. I'm here today to fight for basic human rights at Rikers and as a volunteer with the Beyond Rosies and the Justice for Women Task Force. Today, I want to highlight the urgent need of women being held in custody and the systematic failures of the Department of Corrections. The Department of Corrections is violating the rights and health of those being held apart and denying them basic medical and mental health care. This must end now. The authority for making healthcare decisions must rest solely with the Correctional Health Services Professionals, CHSP, not correctional officers. Correctional officers should not be able to withhold medical visits by treating physicians based on safety, rehabilitative, or behavioral, or any other reason. Your own office recognized this in the second report and recommendations on the 2024 deaths in New York DOC custody, which identified this as a critical issue in the tragic death of Charisma Jones. Charisma Jones, a 23-year-old woman, was repeatedly denied life-saving medical care for 77 days. Several medications prescribed for mental health have black box warnings for life-threatening rashes. Charisma Jones developed this rash, Stephen Johnson syndrome, after a mental health med change. The extreme pain and suffering she endured for over 2 months was a direct result of the DOC's failure to grant her access to a doctor with this basic knowledge. Her death was preventable and entirely the fault of the system that repeatedly denied her care. She burned to death from the inside out, and her pain was so severe that her behaviors and demerits were likely desperate attempts to receive treatment. To prevent any other tragedy, we demand mandatory training to all staff, including correction officers, to screen and obtain immediate medical attention for Stephen Johnson syndrome, a known risk of several psychotropic medications. They need to understand the urgency of this condition. Accountability: we require immediate review of the medical licenses of all professionals who fail to diagnose and treat Mrs. Jones. The psychiatric protocols must be also examined by the Office of Mental Health and the Board of Psychiatry to ensure this never happens again. Immediate access. We insist that doctors and psychiatrists be the only ones to make medical and mental health decisions. Correction officers should never be allowed to withhold medical visits based on safety, behavior, or any other reason, non-medical reason. Transparency. We require that the Board of Corrections provide us with specific data on cases of Stevens-Johnson syndrome and other life-threatening conditions. We also demand that the medical director of Rikers facilities attend and testify at all future Board of Correction oversight meetings to ensure transparency and accountability. Prevention. We ask that the Board of Corrections provide us with the number of individuals diagnosed or suspected to have developmental disabilities, intellectual disabilities, or significant cognitive impairment due to traumatic brain injury. Add Mester Levels board certified behavior analysts to every unit, every waking shift, and increase staffing so people respond to emergencies. The protection of staff, while important, does not erase our responsibility to ensure the health and safety of those who are being restricted by the carceral system. Medical professionals are the only ones qualified to make medical decisions. Mental health is healthcare, and the authority of medical doctors, nurses, physicians assistants, psychiatrists, therapists, and social workers to see their patients should be absolute. Make it happen immediately. A memo is not enough.
Yes, if you can finish now, you went over your time.
Yes, Charisma Jones, age 23, was severely and painfully tortured for 77 days. Her torture and subsequent death was a direct result of the Department of Corrections' gross neglect. It should have never happened. Thank you.
Thank you. Chaplain Dr. Victoria A. Phillips, followed by Natalie Fiorenzo.
Peace and blessings, everyone. I'm Chaplain Dr. Victoria A. Phillips, Dr. V, everyone knows me, member of the Jails Action Coalition, Beyond Rosie's, Halt Solitary, Justice for Women Task Force, and many others. A few things I just want to highlight in no random order. DOC's data is usually always incorrect, and this board already knows that because you've already had DOC provide data, CHS provide data, and do your own data, and you realize DOC has the biggest discrepancies. Please remember that. I also want to highlight, no one on this board actually needs an invite from DOC to go to Rikers Island or any DOC facilities. Please utilize your authority. Also, I would like to say, DOC always comes up and presents as if they're doing great things. There are people in this room, part of the Jails Action Coalition, that were part of a visiting group that worked with DOC many years ago when we first introduced visiting buses and all of that. Then they stopped that. Ask them why, because now they're presenting it to you as if it's this grand new thing that they're creating, and they have not done anything for the people without us advocates pushing them to do so. And it's another example of being on that hamster wheel. They change the name, throw something out with new board members and act like it's a whole new idea, but they're not consistent in anything that they produce. And I just want to say, September is the focal point for suicide prevention, right? So this is extremely important for all of us to touch on. But before I go into that, I also want to say every recording that I heard today, I actually have a recording at home or some recordings that I've already played for this board that are very similar. So none of these things that we heard today are new. Accountability has to be a part of the solution. So JJ mentioned Bradley Ballard. In September 2013, Bradley Ballard was murdered by the Department of Corrections. And I use such hard words because the medical examiner ruled his death a homicide. His death was ruled a homicide after 6 days of being denied medical care. Sounds familiar? Charisma Jones, 2024, right? I've stood up here with this exact obituary that I created. See the back of it? visionaryv.com. That's my ministry. So when I ask you to hold yourselves accountable, I want you to think, what did it take for Carissa's mother to work with me, to go through all these pictures, to create the last thing that anyone would have of her daughter? No one thinks about the heartbeats and the real families that are attached to the lives lost in our system. But I want you to hold yourselves accountable when you feel too tired to go to Rikers, when you don't want to really get political and deal with DOCs in certain ways. I want you to think of Charisma Jones. I want you to think of Bradley Ballard, because remember, this is 2013, this is 2024, and we're still talking about the same things, the same violations, and the same reasons people are dying underneath your oversight. Peace and blessings.
Thank you, Natalie Fiorenzo, and then we'll move to callers online.
Hi, everybody. Good afternoon. My name is Natalie Fiorenzo, and I'm a senior corrections specialist at New York County Defender Services. I want to thank the board for the great value of today's meeting. In the few years that I've been testifying at these hearings, advocates have never had the opportunity to prepare their own presentation, to speak for more than 3 minutes, or to provide in extensive detail to you or the general public what we know happens on Rikers Island. Specifically with regards to the access to counsel issue. As you now know more than ever, this is a really, really serious problem. The ad hoc nature of visit procedures are unsustainable, and I know that they're ad hoc because there's one office that can always seem to fix them. If I am signing into a video conference and I'm told that a client cannot be produced to a visit or that they will be seriously delayed due to an incident or a lock-in their housing area, I call the Criminal Justice Bureau. When I explain to any person in that office that I'm having an issue meeting with my client, the client is produced almost immediately. As the judge said, the exception cannot be the rule. Putting us on the agenda today was such an important step towards making real improvements in the lives of our clients and loved ones on Rikers Island. So again, thank you very much for that. Not only was there an agenda item for public defenders to present, but the rest of the agenda reveals a board who is interested in concrete change and getting answers to unanswered questions. The department has tried tirelessly to turn us away from looking at their own staff when thinking about how illicit substances are getting into the jails. But today on the agenda was last year's DOI report, a culmination of thorough investigating done by an outside agency who found that that is exactly where we should be looking. The department glosses over multi-day long lock-ins, often facility-wide, but today you push them to divulge the magnitude and effects of these unwarranted actions at OBCC. The department boasts that 6A is working for them, but is it working for the individuals who are losing their minds in 95-degree cells, who are missing countless medical appointments, or who are losing their lives? You must continue to push them. The fact of the matter is this: the petty arguments that happen in this room every month about mail are overdoses and brand new addictions on the island. The discussion over technicalities of lock-ins, over out-of-cell hours and security, are suicides, untreated medical emergencies on the island. The death toll this year is astounding. It is completely unacceptable. It is tragic. And it is the definition of insanity to allow the department to keep acting the same, expecting different results. Meaningful agendas like this one, relying on outside investigations, hearing out the rest of the people in this audience, and not just the ones wearing a badge, that is how we will help those who are stuck on Death Island. Thank you for today, and I hope to see more meetings just like this one ahead.
Thank you. So our first person remote is Veronica Vela, and that will be followed by Eileen Mayer.
Hi, Veronica. Good afternoon. Can you hear us? Oh, are you unmuted?
Thank you. Sorry about that. Good afternoon. I sincerely thank the board members who today asked what the next steps are to address the problems contributing to the tragic deaths in our jails. An essential part of the board's death investigation reports is the identification of areas where something went wrong and the suggested fixes to these systemic problems. But I see no indication that DOC implements the actions recommended in these reports, and people keep dying. At this point, the failures common to these deaths are familiar: medical needs ignored, chronic failures of supervision. So why haven't they been addressed? These issues are entrenched, but they are not inevitable. Solutions do exist. but there has to be a true commitment by the department to make change. And because they are so resistant to change, it is the board's primary responsibility in this moment to demand and monitor DOC's implementation of their recommendations. It's been almost a year since former CHS employee Justina Rosinski reported on the horrific conditions she witnessed in the mental health units. She described people with serious mental illness locked in their feces-smeared cells for days on end, decompensating without any access to recreation or services or even medical care. The board investigated, and in June it issued a report that found locking people in was more prevalent in mental health areas. And the board stated that DOC must discontinue the practice of unauthorized deadlocking and recommended audits of logbooks and surveillance footage, targeted training, discipline of staff who engage in this process. And in response, DOC made only meager promises to reinforce its current policies. And then in August, Ardit Billa, as many people have noted today, was found unresponsive with feces on his body in his cell, which he had not left for days in a mental health area. Where is the accountability? We need affirmative solutions, not the occasional 30-day leave for staff only for them to return to work on the 31st day. Instead of the defensive denials we heard today, we need the facility leadership and central office to acknowledge that excessive lockdowns of both individuals and entire housing units are a real problem, and we need a plan of action to start reducing these lockdowns. What we don't need are more restrictive units. Despite DOC's past lip service to positive behavior incentives, it seems in practice the attitude is still lock them all up. The SMU is only DOC's latest rebranding of segregated housing. The board has found the SMU to have restricted out-of-cell time, excessive use of restraints, inconsistent access to services, and inadequate documentation of medical visits and legal visits. We thank the board for insisting that these qualities qualify SMU as a segregated housing area, and we look forward to the board's further oversight of the SMU with recommendations for how we can bring it into compliance with the minimum standards and steps to ensure that these recommendations are implemented before the next death is in the SMU. Thank you.
Thank you. Eileen Mayer, followed by Peggy Herrera.
Good afternoon, Eileen. Please unmute yourself when you're ready. Oh, let me send her a request.
Okay. Can you hear me?
Yes, we can hear you.
Good afternoon. My name is Eileen Marr. I'm a civil rights union leader from Vocal, New York, a member of Freedom Agenda, a social worker, and a harm reduction specialist. I am also a survivor of the abject hell that is Rikers Island, where I spent over 27 days fighting a case. Before I go any further, I would like to offer my condolences to the family and friends of Jimmy Avila, Ardit Billa, and the individual who died on September 4th. I did not have their name when I wrote this. I apologize for that. Who has yet at the time to be named. All three, plus the several preceding them, who have been murdered on Rikers Island. Grief over the death of a loved one is one of the worst series of emotions and pain that anyone can experience, especially when the death, such as these, several deaths, more than several, could have been prevented. The reality of the situation is that, in fact, in 2 very short years, Rikers Island must close legally. This must occur, for this is to happen in the smoothest manner possible. Decarceration and should have already begun years ago. It has not. And one key component of the decarceration and eradicating, recidivism is for the detainee to have ample access to their attorneys, access that protects attorney-client privilege. Clearly, this is not occurring. When I was detained on the island, my own phone call recording in their entirety was provided to the ADA. And many innocent conversations, like one about General Hospital, were purposely misinterpreted by the ADA irreparably injured my case. So this issue is not new. Another factor that plays into decarceration and reducing recidivism is in maintaining one's familia and community ties. The way one accomplishes this is through visits, phone calls, and correspondence, especially snail mail letters. The actual letters, not Xerox copies. While I was detained and incarcerated, just feeling the paper that my mother had used to write me a letter added an extra piece of comfort to me. As for visits, all visits, face to face and not via a booth or screen, must continue. My favorite part of my visits were the hugs my brother and my best friend would give me at the beginning and the end of our visits. Those hugs not only provided love and assurance of their unwavering support, but gave me more strength than one could fathom. Strength to persevere through the horrendous and unnecessary nightmare I was going through while detained and later while incarcerated, and thousands of others, detainees and persons incarcerated, agreed to the same sentiments, thus making all visitation and correspondence imperative to reducing and eventually eradicating not only recidivism, but mass incarceration in its entirety. However, human touch and the security of client attorney visits are not only are the oh excuse me I'm sorry are not on- are the are the are just two of the ingredients needed to close Rikers Island. There are much more. Rikers Island must close. Alternatives to incarceration, drug and alcohol, medicinally assisted treatment for addiction, substance abuse disorder
Eileen,
treatment.
sorry to
And
interrupt you, but you're
I'm
over
almost
time.
finished. I'm
Thank you.
almost finished. Can I finish?
Yes,
I
please.
just have a few more left.
Thank you.
Programs and community violence interrupters are a must. In addition to this, supportive education, psychiatric and medical housing services, childcare, library, community programs, harm reduction services, community sports and athletic programs, adult education programs, and programs aiding those not born in the on U.S. soil to easily become naturalized citizens are all equally imperative. Also, DOC must stop preventing the detainees to participate in therapeutic, educational, and medicinal and family reunification programs because they are don't let DOC
Excuse
fool you.
me,
Nothing.
excuse me, we're gonna have to ask you to end now. But
Okay. In
thank you for
conclusion,
your testimony.
I have more to say.
Thank you.
All right.
So we have two names, Peggy Herrera and Danielle Gerard, but we do not see them as being on remotely anymore. Is there anybody else on the remote who had signed up to speak that we didn't have on the list?
Let me take her down.
Okay, we have one.
Okay, Aubrey, did you want to speak? Okay, I see your hand, Aubrey. I'm going to send you a request to unmute. You're good to go.
Aubrey Aguinaga.
Aubrey, you're good to go.
Yes, thank you. Sorry, one moment. Is everyone able to hear me?
Yes.
Okay.
Yes.
Good afternoon, everyone. My name is Aubrey Aguinaga, and I'm the prisoner's rights attorney at the Bronx Defenders. And I thank you for this opportunity to testify today. Every day, the prisoner's rights practice receives dozens of referrals from legal teams comprised of attorneys, social workers, and advocates. As such, we get insight into many of the issues that our clients face while in DOC custody. I'm going to touch on just a few that have been reoccurring over the last few months. We have gotten multiple complaints from clients who, after months of being at Rikers, still do not have access to tablets. This is a violation of DOC's directives and blatantly contradicts the testimony given by DOC officials to the board time and time again. On many occasions, DOC staff have gotten up here and assured this board that everyone in custody has access to a tablet within 30 days of intake. They have claimed that the only people in custody who do not have tablets are those who have either lost or damaged their tablets. That could not be further from the truth. We have heard of many instances where our clients have been in custody for well over 3 months without a tablet. Most recently, we spoke to a client in EMTC who, after 4 months in custody, was told that he and the others in his housing area would likely not get tablets before the end of the year because the housing areas they were in were not equipped with Wi-Fi. And thus, as long as they were there, they would not receive the benefit of all that is available to other people in custody. This is unacceptable. It cannot be that your access to a tablet depends on what housing area you're in. The tablet program was rolled out almost 2 years ago. DOC needs to stop with the excuses and ensure that their facilities are able to accommodate everyone in custody. Additionally, DOC staff needs to be held accountable for lost and misplaced tablets. Far too often, we get complaints from clients who state that they give their tablets to officers in the bubble to charge, only to return a couple hours later and be told that their tablets have gone missing or are no longer working. When this happens, DOC does not replace the tablets. Rather, they blame our clients for the loss. Our clients are then penalized and told that they will no longer be getting another tablet during their incarceration. This is outrageous. Tablets are essential for our clients to stay in touch with loved ones and their counsel. They provide access to the digital law library, programming, movies, music, books, etc. They are hugely important to our clients. They allow for time to be spent in a productive way and ensure the necessary access that they deserve to their loved ones and legal team. Next, I'll be addressing lockdowns. Excuse me. This has been an ongoing issue for years now. This board even launched their own investigation into the countless complaints from people in custody and their loved ones. However, the findings in the most recent Board of Corrections report are a bit concerning. Specifically, the finding that there were only a handful of lock-ins that were impermissibly imposed. To the contrary, many of our clients in RNDC, OBCC, and GRVC complain of frequent and sometimes lengthy lockdowns. Most of the time, they explain that this is a tactic used by staff to punish entire housing areas for the actions of only a few, or it is a way to deal with staff absenteeism. Sometimes these lock-ins are initiated merely to ensure that certain officers can have a smooth tour and not deal with people in custody. Regardless of the reason, these lock-ins continue to be abused by DOC staff. They often lack a nexus between what is occurring in the housing area and how long and who remains locked down. The practice is particularly egregious when imposed in MO units. Yes, this is still happening to people with SMIs in MO units, one of Rikers' most vulnerable populations. People in custody on these units often deteriorate and languish in their cell for days, sometimes just because officers don't know or don't care to know how to deal with their illness. In fact, one of my colleagues who is here today had a client on one of these MO units. That client says he was recently on a 4-day lockdown for defending himself. During this period, guards were not checking in on him. He could not take a shower. He was not being fed regularly. He did not have access to his family or anyone in the outside world. The only time he left his cell in those 4 days was when he was brought to court. My colleague didn't even know his client had been deadlocked until his client was finally able to tell him once he arrived in court in person. This client has an SMI and his attorney is worried sick about his well-being. This should not be happening. We urge the board to continue to monitor this issue, specifically in the facilities mentioned here. Lastly, over the last several months, having timely access to our clients' institutional records via FOIL requests has become increasingly difficult. Even though we are supposed to have access to the records requested within 20 business days, it now takes upward of several months to get a response. And when we do get a response, the records are typically incomplete, which can add several additional weeks to the waiting claim. This severely limits our ability to effectively advocate for our clients, and these delays prevent us from timely appealing disciplinary infractions, challenging security classifications that restrict our clients' movement and housing options, and ultimately shield DOC from scrutiny and public accountability. We ask this issue be addressed by the board as soon as possible. Thank you.
Thank you. I think that concludes public comments, but I'd like to say that, Ms. Roby, thank you for your comments. We will look at the tablets issue and conduct a survey as to the Wi-Fi effectiveness for the tablet use in the facilities on Rikers. At this time, I'd like to thank everyone who attended and participated in today's meeting. The board's next meeting is scheduled to take place on Tuesday, October 14th at 1 p.m. At this time, I'll take a motion to adjourn.
So moved.
Is there a second?
Second.
All in favor? Meeting is adjourned.